One method man's urgent is this. This National Highway Authority acquired some land. Where the 6% get apportionment. 3 sisters, 3 brothers. 3 brothers sold out the property in favor of third party. Now third party wanted the execution of distribution of taking out 20 crore, 21 crores rupees. 6 crores has already taken. Now there is a direction to immediately deposit the amount so as to release the amount in their favor. In this process, so urgency is that manner. Take up next week.
It has been constructed more than 11 years ago.
Page 6, item 30. 2 week time for counter affidavit.
Yes.
Page 6.
Page 6.
Item 30.
Oh.
I am for opposite party. 2 week time for file counter affidavit.
That is for admission for admission. 30.
WPC 125175. MCL. MSC.
You are appearing for whom?
Appearing for opposite party.
You are for the opposite party?
Yes.
Which opposite party? On whose behalf you are making mention, madam?
S.K.Dash Mahapatra.
Is appearing for whom? Suryakant Das Mahapatra. Or opposite party number 1 and 3. Opposite party number 1 is the chairman, so and so 3 is this. Acha. The mention is made on behalf of the Land Council. For the have you got power in this case?
Yes.
What is your name?
Sujata Vardhan.
Huh?
S. Vardhan. S. Vardhan.
S. Vardhan. S. Vardhan. Acha, category. Miss S. Vardhan, Land Council appearing for the opposite party number 1 and 3. 6 for an adjournment. File counter affidavit. Put of this matter. Give another date. Yes.
Placement.
Patent mention CRL number 328 2018 appellant in custody since 12/8
Yes.
patent mention CRL number 328 2018 the appellant is custody since 12/8 2010 under section 302
The list, item number 1.
Number 1.
On behalf of 1 and 2, kindly pass on, Mr.
On behalf of Mr. Ashutosh Mishra, place for withdrawal or to file a better application.
The Land Council for the petitioner, 6 permission, files a memo for withdrawal of the petition to provide a better.
Lordship, annexed 2, 3, and 4 of the certified copies may be written substituted by
The certified copy of annexure 1, 2, 3.
2, 3, and 4.
2, 3 and 4 be written to the Land Council on being substituted. The Xerox copy. Here.
Item 2.
May I please election? What is this report? SR report is?
initially it was wrongly listed before a honorable single judge, so then it went to the SR Miller, then it was corrected and now it's before.
Further found that the matter related to
the case of cancellation of lease, so this is the appropriate.
Yes.
Yeah, this your lordship. But this is a matter where state has on caveat and we have already served on that. But the background of this matter is
What is the prayer in this thing?
sorry, Malad.
What is the prayer in this
The
case?
prayer in the writ petition is to quash the order of quashing the cancelling the lease, and for a refund of the performance guarantee, which has been forfeited by them. Performance guarantee of 3.5 crores. Well, the petitioner before your lordship is a leading chain of hoteliers in the country, but it goes by the brand name of Hyatt. There are about 12 luxury hotels in the country and even outside the country is owned by this group, my lords. Now, they wanted to open a property in Bhubaneswar. Accordingly, my lords, there was this property which had been leased out to another company and they were unable to put it up, and there was some litigations going on in that. So in that litigation in 2014, a compromise was arrived at. And by virtue of that compromise, the petitioner came into the picture. And the petitioner got between who? The state government and the petitioner. And the first while allottee and the petitioner. Okay.
In 2014?
2014.
In 2014, I think you filed another writ was there.
That was in 13 by the previous lessee. The previous lessee. Now kindly take page 66, Manoj.
So the tripartite agreement was entered into only in 2014?
Not in 2006? Document.
Not in 2006?
No, that was different. That was initially we entered into a tripartite agreement in 2006
with the government.
With the government and the other person. Their lease was cancelled. That matter came up to the High Court. During pendency of that matter in the High Court, a compromise was effected, and on the basis of the compromise, the case was disposed of, and that compromise document is at page 63.
Mr. Mukherjee, if I remember correctly, if I have read correctly,
yes,
that is not the one that you are submitting for the court.
Sorry, Manoj?
That is not the manner in which the fact has been developed in your writ petition. Probably the writ petition is something else. The writ petition goes like this,
yes,
that initially the lease was in favor of Asian Hotel.
Correct.
In 1997.
Yes, Manoj. 96.
96?
Yes,
your time is 97, kindly see. 1997.
Yes, Manoj.
And subsequently, because they could not put up, or you posed yourself to be one of the subsidiary of Asian Hotel.
Yes.
And accordingly, you entered into a tripartite settlement.
Yes, Manoj.
And the lease was granted in 2006.
No.
Which was finally granted in 2009.
The agreement was executed in 2006.
What was in 2006?
Yes.
Lease was granted according to you in 2009.
It is
correct?
Yes.
That is what is your fact.
Yes, Manoj. Now,
and one of the ground of the lease that you must get up all the constructions within 36 months.
From the date of
lease.
No. That is what I'm trying to show to your lordship.
No, that is what your...
I'll show to your lordship. Just bear with me for a minute. Kindly come to page 63.
No, that is a subsequent one. New. That is why I am interfering.
Everything boils down to that. A new chapter is opened in 2014, where the state government is a signatory.
Right. And in that case...
compromise is executed between the governor and the petitioner, where, my lords, certain terms are set forth.
Correct.
Kindly take, my lords, that document,
yes,
Annexure 3 at page 63.
Correct. That is Annexure
3, page 63. This is dated the 12th of September 2014. This is between the government of Orissa and the petitioner.
Right.
Now, my lords, kindly come to page 66. This answers your lordship's question. 1, subclause 2. The lessee will complete the construction of the building and structures over the scheduled land within 36 months from the date of approval of the building plan by the Bhubaneswar Development Authority.
Right.
This was in 2014.
Right.
Now your lordship knows that this was a period of flux. The 74th Amendment of the Constitution came in, by virtue of which BDA or the development authorities were subsumed into the municipalities. Now, the plan could not be made to the BDA. Ultimately, after soil testing and we could submit the plan that is at page 78. No, page, sorry, page 72. 2017, the building plan was submitted for construction of a hotel building G+7. Has your lordship got
Yes,
it?
yes.
Now, my lords, after I submitted this plan, the Bhubaneswar Development Authority, the Bhubaneswar Municipal Corporation, under Annexure 8 at page 78, they write to me after 2 years. Kindly take page 79, the handwritten portion. Submit clearance from the Archaeological Survey of India as the project area is situated partly within 100 meters and partly within 100 to 300 meters from the outer boundary of Udaigiri Cave, a centrally protected monument. Now, my lords, when we go to ASI, the ASI tells us that yes, you have to take a permission, but it is not the ASI, it is the Department of Culture, Government of Orissa, the National Monument Authority. Now, my lords, accordingly, I make on this immediately I make an application which is on the next page, page 80. Page 80. May I place this, my lords? Request for issuance of clearance certificate or no objection certificate for our 5-star hotel project at the project site, around 7 acres. This is to inform you that as desired by the senior municipal planner, Bhubaneswar Municipal Corporation, so and so, while letter dated so and so, we would request you to inspect our site as mentioned herein above and issue us a clearance certificate or no objection certificate for necessary approval of a building plan submitted at BMC for upcoming 5-star hotel project at Khandagiri. Next, last but one penultimate paragraph. Needless to say that apart from the aforesaid enclosure, if you need any more clarification, we are ready to serve you. Please contact with the undersigned at contact number so and so. This letter was given in 2019, March 2019, immediately upon Bhubaneswar Municipal Corporation asking us to get this clearance. Next, your lordship sees at page 107, when the building plan was being processed, what was found was there was a discrepancy in the area. Page 106. Page 106, I write a mail, the text of which is at page 107. This is again draw your attention to the discrepancy in respect of the area of the leasehold land, which is as follows. Area of the plot as per the lease deed is 7 acres. Area of the plot as per the plot survey is 6.127 acres. Survey report is attached. Area of the plot as per the lease agreement on the basis of the dimension shown is 6.048 acres. Layout as per the lease deed is attached. Kindly request you to review and clarify in this regard and also reply to our following mail. Now, at page 117, they respond to this. Kindly see the date. This I had given this letter on 13th July 2022, the email at page 106. Now, on 13th of March 2024, Annexure 19 is the response. Has your lordship's got that?
Yes, yes.
Kindly say, take paragraph 5. In this regard, it is clarified that the government in GA department had transferred allotment of government land measuring 7 acres in Mauja Jagmara in favor of so and so for construction of hotel project. Accordingly, you have also executed a tripartite transfer lease deed with the government for the same 7 acres with GA department and PG department so and so. Further, you have also taken physical possession of 7 acres of leased out government land from the GA department. Thus, now your submission of less lease area does not have any legal basis. However, further field verification can be considered to reconcile the matter. This is from the GA department, Joint Director. Now, simultaneously, almost when this letter is given, on at page 116, kindly see. This is the letter from Bhubaneswar Municipal Corporation. This is dated the 6th of February. Here they say, hence in exercise of powers under subsection 3 of section 16 of the ODI Act, permission to undertake development on plot number so-and-so of Bhubaneswar Municipal Corporation is hereby refused on the following grounds. Failed to submit clearance from the Archaeological Survey of India as the project area is situated partly within 100 meters and partly within 100 to 300 meters from the outer boundary of Udaygiri Cave, a centrally protected monument. And the protectors of monument, when do they respond, my lords? Page 122. Now, kindly see page 121. 121 is my letter, wherein I refer to 5th March 2019. Your lordships will recall this is that letter when I wrote to the culture department for the no objection certificate. Am I clear, my lords?
Yes, yes.
On 5th March 2019. So with reference to that letter, I'm again writing to them. In the meantime, BMC, while letter dated so-and-so, has refused its permission to undertake hotel construction on the schedule pause due to failure to submit clearance from ASI. We have been in touch with the office of the BMC, and BMC has now asked us to submit revised building plans in term of ODA rules for 2020, which we shall be doing soon. We may have to file revised building plan with you if required, as in any case there would be construction activity inside our plot within 100 meters from the outer boundary of Udaygiri Caves, a centrally protected monument. In the meantime, we request you to process our file and give us a NOC at the very earliest so that the requirement of BMC is complied with and our building sanction plan is not refused, and we can immediately start the construction of the plot. Now, after this, at page 122, on 5th of May 2024, the culture department wakes up. And what do they say, my lords? Subject issuance of NOC for 5-star hotel at so-and-so, your letter dated so-and-so. In inviting a reference to the letter and subject cited above, this is to inform you that you have submitted required documents except Heritage Impact Assessment Report. This document is quite essential for processing of file and conducting joint field inspection by the team comprising officers so and so, so and so. So, my lords, now after cancellation of the lease, the Department of Culture says that there is one document missing, and that document is a Heritage Impact Assessment Report. This is after 5 years after I have made that application. This is the first response I'm getting from them.
This building plan was submitted only in 2017.
In 17. 14, I got came into
No, but
possession.
I don't agree with you in your correct. Please come to paragraph.
Which
Paragraph 8
of the writ petition. Yes, Maharaj. That thereafter on 12/12/2006, a tripartite deed of lease was executed to the state government for transfer of the land in favor of the petitioner company. Though the same was executed, the original copy of such lease deed was not handed over to the petitioners. It is submitted that the same was vitally essential for the petitioner company to go ahead with the project and seek financial assistance from various financial institutions, including bank. Now, Maharaj, this happened.
And the petitioner company waited till 2009.
Sorry, Maharaj?
Petitioner company waited till 2009 when the original was given to it.
The 2009 it was given.
Correct 10.
Yes, Maharaj. 2009.
So from 2009.
Yes, Maharaj.
Obviously, the lease has been granted in your favor.
But there was a cancellation thereafter.
No. Cancellation
Yes,
because you failed to comply the condition of lease and went on asking for extension or after extension.
No,
and it has been allowed.
No, Maharaj, that was when the first lessee was there.
Whatever it is. It has come to you in 2009.
In 2009.
And after that
given to me in 2014. Not by the virtue of the...
this is not your writ petition then.
Sorry, Maharaj?
This is not your writ petition then. Your writ petition is very clear that the writ was initially... See, the lease was... You have only declared yourself to be the subsidiary of Asian Hotel. And accordingly, you got the lease transfer in your name. That is how a tripartite lease.
Yes.
Otherwise, Asian Hotel has nothing to come. Tripartite settlement was there because you declared yourself to be one of the subsidiary.
Well, Your Lordship, may I just, for the purpose of this, give you Your Lordship an example?
Come to the date chart that
Yes.
goes to what my brother is.
I do get your Lordship apprehension. Let me try and explain that. My Lord, there used to be a company by the name of Team
What
Play.
we need is, let the company be truthful.
My Lord,
Why I am saying the niceties of preparation of the language in the read appears that all has been attributed to the government and the government did not do anything since 2014 to 20.
They were slow.
No, not at all slow. Government has time and again reminded you to complete the lease. See, it's an important piece of land given to you for the purpose of bringing the property of hotel.
Yes.
And you you are holding the land since 2006 and not bringing the property by some pretext or other till 2017 when you are for the first time giving a building plan to the government. For the first time. So you hold the property since 2006 till 2017. That is what is a matter to be seen. And if the petitioner company is a lessee and is not getting the lease deed original, what step it would have taken? Nothing.
My Lord, may I again invite your Lordship's attention to page 66.
Right. 66.
Yes.
Right. Yes.
The lessee shall withdraw the writ petition bearing... Lessee means
yes.
Asian Hotels.
Yes.
The lessee shall withdraw the writ petition bearing WPC number so and so filed by them for challenging the General Administration Department order of determination dated 1/11/2012.
So lease was determined earlier. Huh?
Yes. So that is where... Now, this was the flux, my lords. This was the flux. My lords, may I just explain the simple corporate, how it works, these corporate machines work, my lord. Your Lordship knows there's a very famous company known as Tin Plate. Now, Tin Plate was a subsidiary of the Tatas. Your Lordship knows what Tatas are. But Tin Plate became sick. So ultimately, Tatas took over Tin Plate. This is exactly the same scenario. Asian Hotels became sick. They did not have the requisite funds to go ahead, or they had some difficulty with which they could not execute the lease. That is why the petitioner stepped in. Because the intention, my lords, is very clear. The intention was to put up the hotel. Otherwise, this company would not have sunk 10 crores. They already have given 10 crores.
No, 10 crores was
3.1 initially for the lease.
3 crore, 10 crores was in phase manner because so long you did not comply the.
True, my lords. But anyway, the fact remains that 10 crores has been invested by this petitioner
Right.
on this project.
Correct.
And that was also, this included an amount of 3.5 crores at a time when the hospitality industry was in the doldrums during COVID.
No, that is.
Everybody was running away.
No. From 14, when the matter again, as if we agree with you, if it has come to you in 2014, the term was again to complete it within 36 months.
36 months from the date of approval of the plan.
Ah.
Now, my lords,
So when you will place the plan?
my lords, I cannot just go and put a plan before this development authority. Now, before I put in the plan of a 5-storied building or a 7-storied building or a skyscraper, I will have to do some preliminary work. That is, I have to get this all tested. I have to do the layout thing. I have to get the plan designed by an architect. Because
these are all known things, sir. These are all known.
It does not happen overnight, my lords. Your lordship knows that even an individual, when he goes to an architect, he does not get a plan overnight. If I make an application as an individual to the development authority for approval of my building plan, I myself have waited for 1 year to get that plan approved. This is the scenario. And here, my lords, such a huge investment is going to take place. And these are not fly-by-night operators, my lords. These are people who have put up 11 to 12 luxurious hotels in India. They're all there. They have a reputation in the hospitality industry. They are next only to the Taj Group and the Oberoi Group. And Manoj, had the intention not been there, why would I be writing this series? I am not bothering your lordship with all the communication that I've been making to them over the years, day after day, none of which have been responded to. I'm sending emails in the morning, I'm sending emails in the afternoon when the show cause notice is issued to me. And my lords, now your lordship may kindly see the sequence of dates, my lords.
Right.
What they do, they issue a show cause to me. Page 139. This is the show cause. This is 28th, the day of May 2024. This was at a time when the code of conduct was already in place. Election code of conduct was already in place. They give me the show cause notice. What is important is at page 140. Last paragraph of that page. And whereas, by not fulfilling the terms and conditions for performance of the guarantee communicated by letter dated so and so, the performance guarantee dated 7/6/22 and 37/22 submitted by you to this department has been forfeited without a show cause. This is the show cause, and it has already been forfeited. Now, your lordship knows there are a line of judgments where the show cause already heralds what the conclusion is going to be, or specialist case, my lords. That show cause itself is liable to be quashed. Your lordships have done so time and again. So this show cause is given at page 141. You are therefore called upon to show cause within 15 days from the date of receipt of this notice. So and so.
Now you submitted representation.
I submitted representation. I put forth everything that I had to say. Why? And I also requested for a personal hearing. Detailed show cause your lordship sees. Detailed one. Kindly see at page 147, last paragraph. In this connection, we also seek an appointment with you to be physically present before you to give you necessary updates, including the appointment of architects and other steps taken already on board.
Okay.
Then fatapat.
And thereafter at page 148, sixth kind reminder, request for your appointment. Thereafter, your lordship sees the response ultimately 159. They respond on 27/6/24. Has your lordship got page 159? Reminder after reminder, my lords, and then they respond. They refer to my representation, then say, inviting a reference to the subject cited above, I am directed to say that your representation for discussion with the Director of Estates and Joint Director of Estate has been regretted, as you have not taken any steps with diligence for proper utilization of the leasehold. This is a predetermined thing, my lords. They have, most in all probability, they have chosen one. And I filed this case, and since the state is on caveat, I give them an advance copy. And during pendency of the case, what do, my lords? Kindly come to the additional affidavit, which I have filed, flag B.
So, Mr. Mukherjee,
Yes, my lord.
if you come to that annexure 25.
Annexure
25.
25, yes, my lord.
Notice, in the operative part of that 141.
Yes, my lord.
It is mentioned that you are therefore called upon to show cause within 15 days.
Yes, my lord.
As to why the said list shall not be determined.
Yes, yes, my lord.
Then you give your representation, right? That is the annexure 26.
Yes, my lord. Within 3 days, I gave the representation.
Then number of email correspondence were made for having that personal
Yes, my lord.
So that was what has been brought down in annexure 28.
Yes, my lord.
But the fact remains that your lease has not yet been determined.
Yes, my lord. That is why I was inviting your lordship's
Yes,
attention to the
that's
additional
there.
affidavit.
Yes.
After I had filed the writ petition, when the matter was sub judice before your lordships, annexure 29, additional affidavit, flag B, kindly take page 6. 2/11/2024.
Yeah.
Determination of lease in respect of drawing number so and so, leased out in favor of so and so. Petition.
So that means you need to then amend your writ petition and insert it by the prayer portion. It is to be, this thing is to be challenged.
That I will do. Definitely, I will. Since this was a development which has taken place post my filing, I have brought it to your lordship's notice. I have brought it in the miss case also.
Yes, yes.
So have you filed that amendment petition, amending your prayer portion as well as some of these? Maybe you may take some grounds also in the writ
That,
petition.
my lords, I will look into it. But indeed, that has not been filed as of now, because it could not brook any delay. I had to urgently move your lordship and your lordship's registry for getting this matter listed.
Yeah.
Because by this letter dated 2/11/2024, I have been given 15 days time, which expires on the 17th.
What order was passed on to?
2/11. This determination, my lords, page 6, that flag B, additional affidavit,
Yeah.
dated 2/11/24, at page 8. Just before the schedule, paragraph. Now, therefore, the government, after careful consideration, has been pleased to determine the lease under clause 4I, read with clause 4IV of the lease deed, with effect from the date of issue of this order. So and so is hereby directed to remove the structures and materials, if any, from the demised premises within 15 days of issue of this order, and make over weakened position of the leasehold land to this department, failing which the department may cause such removal and recover the cost thereof from the excess.
So you mean to say that if this is not stayed, then immediate action will be taken.
Yes.
That is,
Yes.
otherwise you have to amend the writ petition, make necessary amendment also in the.
I will do that. I will do that. But this miss case subsequently filed, I have prayed for stay of this miss case for this year. That is at flag C. That is
Yes, what do you say?
My lords, fact remains, my lords, that Asian Hotels got the lease on 4/4/97. There is nothing in the writ petition to say what development took place between 97 and 2006, which is a period of 9 years and 8 months. It is only in 2006 that this tripartite agreement had been entered into.
Yeah.
The original lease deed also seeks for construction within 3 years. That means from 97 to 2006, Asian Hotels did nothing, provided, of course, there is something that there is nothing in the writ petition. Now, my lords, if we forego all that, in 2014, the new chapter started
Right.
after the revocation date. From 2014 to 2017, no building plan was submitted. Now, whether BDA had been subsumed or whether the responsibilities of BDA had been given to BMC is none of the petitioner's concern. The application could well have been made to the BDA. When BDA functions are taken over the BMC, that application could have been transferred to BMC. That's another story. 19, the application is made to the culture department. Until 24, there is no follow-up. There is not a single letter from the petitioner's side. It's only when the so-called notice has been issued that multiple emails have been sent. Number one. Number two, my lords will come to Annexure 16, page 104, when survey has been made. And how could a building plan have been submitted without a survey? 97 lease is granted. 2022 a survey is made, my lords. So until 22 no survey was made, the petitioner was not even aware that 7 acres was not there in the original lease to lease plot. There is no equity, my lords, here for any stay order. That is my submission.
No, the main problem is that suppose that whether that is a proper site for construction of the hotel or not, that is again to be in view of the
Which is why,
change in the scenario.
which is my lords, that ASI and that heritage, everything has been made.
because
But from 19 to 24, there is absolutely nothing on record, at least in this writ petition. What happened? Now, so many letters have been issued. There is no single letter after 19.
They say about the heritage impact assessment only in 2024.
Yeah, but between 19 and 24, with great respect, my learned senior, my lord, kindly allow me to speak.
That angle is to be the most important criteria. So, because if the heritage problem is there, then certainly he cannot construct.
Well, its fact remains that 97, the lease was granted. The building plan has been submitted in 17. For almost 20 years, it has been lying with the petitioner without nothing happening there, my lords. All these facts could have been, I mean, they were there already.
The petitioner C.DASH Hotel Limited has filed this petition challenging the data dated 28/5/2024 under Annexure 25, so also dated 27/6/2024 under Annexure 28, passed by General Administration and Public Service, a Public Grievance Department, Government of Orissa, with a further prayer for restoration of the return of the performance of bank guarantee given by the petitioner, issued on 7/6/2022, also on 30/7/2022, to the tune of rupees 3 crores 50 lakhs. Mr. Gautam Mukherjee, Land Senior Advocate, drew the attention of this court to Annexure 25, which was the so-called notice issued to the petitioner by the Director of the State and ex officio Additional Secretary to Government, wherein 15 days time was granted to the petitioner from the date of receipt of the notice as to why the lease will not be determined under clause 4.1 of the lease deed, and why the land shall not be resumed and possession be taken over by the government. Mr. Mukherjee submitted that after receipt of such show-cause notice on 30/5/2024 by the unissued 26, show-cause reply was given with all details, in which a further prayer was made for seeking an appointment with the um, authorities um, to physically present the necessary updates, including the appointment of architects and other steps taken, which are already on board. It is further stated that thereafter no response was received from the authority, and the petitioner went on sending emails and letters via Annexure 27 series. And ultimately, by Annexure 28, we received communication from the Director of the State and ex officio Additional Secretary to Government that the representation which has been filed by the petitioner for discussion is regretted, as the petitioner has not taken any steps with due diligence for proper utilization of the leasehold lands, despite of the execution of performance of bank guarantee. This writ petition was filed on 2/8/2024. Mr. Mukherjee and counsel for the petitioner submits that on 2/11/2024, the petitioner received a letter from the Director of the State and ex officio Additional Secretary to Government, opposite party number so and so forth, that the government has been pleased to determine the lease under 4.1 reduced clause 2V of the lease deed with effect from the date of issue of the order. And the petitioner was directed to remove the structures and materials, if any, from the premises within 15 days of the issue of the letter, and make over the vacant position of the leasehold land to the department, failing which the department may cause such removal and recover the cost thereof from the ex-lessee. This document has been filed with an additional affidavit by the petitioner. The Land Council for the petitioner submits that he intends to file an interim application to amend the writ petition, so also the prayer portion challenging Annexure 29, and for that some time may be granted. However, if immediate stay is not granted, which has been prayed for in the IA number 15044 of 2024, the of the order dated stay of the operation of the order dated so and so passed by Annexure 29, the petitioner will be seriously prejudiced. Let the interim application be filed by next week for amendment of the writ petition, so also the prayer portion, and in the next date, the operation of Annexure 29 shall remain state. Yes.
Obvious.
Item number 3.
May I please, Your Lordship? Your Lordship, item number 3, 6, 7, and 8, they are all covered matter by Your Lordship.
Give that.
My lord, the order passed by the referral court. Alternative remedy under Rule 21
No, no, he has
Order 21
stated that some orders have been passed in.
Yes, yes, I have told
Have you verified? So that is annexure 2.
Yes, yes, your lordship.
Annexure 2 is similar order passing. Is there any change, anything?
I have mentioned the changes in the
mention कर दीजिए white हमके found out.
कितना मैटर अछि
कितना मैटर कौन दो?
item 3.5
3, 6, 7, and 8.
3, 6, 7
8.
Yes, your lordship.
All right.
Well, only my submission if no appeal is filed. The national government has also no objection to the aforesaid submission made by the land council for the petitioner if no appeal filed.
no appeal is
I have mentioned in the writ, your lordship, no appeal.
no appeal is all.
The land council for this one to submit that no appeal has been filed. Yes, that's so good. Yes, next.
Item number 4.
Item number 4, may I please, my lord? My lords, the petitioner has approached this honorable court challenging the arbitrary action of the state opposite parties in constructing a village road connecting NH26 to the Koksara village through the private land of the petitioner without acquiring the land or following due procedure as laid by the law. My lord, facts of the case is that one Ramnath Dalpati, under whose name one khata number 108 of Moza Bobria land was recorded in Ramnath Dalpati. Now this Ramnath Dalpati has passed away and his legal heirs have inherited that property. Now,
what do you want in this?
My lord, my only prayer is,
or what?
My lords,
You want compensation?
My lords, the land may be acquired by following due procedure of RFCTLAR.
No, land has been acquired for construction of a that public road.
It has not been acquired. That is the problem. They have constructed.
They are such constructed, but without acquiring the same.
Yes, my lord. They have not constructed. They have started the construction, and since we have protested, they have stopped till now. So my only prayer is that if they want that land, because that land, because without
how this thing can be determined in a writ petition, whether it has been it was constructed in a public road, or public road was constructed taking over your land or not, all these things it requires documentary evidence and maybe oral evidence, and maybe that somebody has to be deputed to for measurement, and there's some documents may be called for from the Tahsildar's office or whatever it may be. So all these things are necessary. How can in a writ petition all these things be determined that somebody was trying to construct a public road that has not been done, and you want to put pressure on them that you acquire my land and then pay compensation, then go on constructing the public road? How can this?
My lord, various facts are there. So many facts.
The representation of the petitioner is at Annex 3.
It is there.
Let them take instructions at least on this.
Which one? Representation is there. Annex 3.
Yes, my lord. Annex 3. Page 15.
All right.
It is pending before which authority?
Opposite party number 5.
Opposite party number 5. Yes.
At least, my lords, if I may pray.
Yes, next.
My lords, if I may pray one thing, I may be allowed to file a fresh representation before OP2 at least, the collector.
Yes, NHA is there, you can file.
So
with the liberty to
village.
If the petitioner the set up at this stage, land council for the petitioner submits that the petitioner may be permitted to file a fresh representation before opposite party number 3 so highlighting the grievances. If any such application is filed within 2 weeks from today, the same shall also be disposed of. See you time here. We have expressed no opinion. Yes, next.
Deeply urged.
Item 5.
In this, the petitioner challenge the action of the opposite party number 2, my lord, not referring the matter to the civil court, my lord, under section 20H clause 4 of the Railway Act, my lord. Fact of the case, my lord.
What is that act? Let us see.
My lord.
What is that act?
Any dispute arises?
Just a minute. Why are you not in advance giving that these are the books necessary in my case so that he will keep it ready and
or a photocopy of
or
that
a
so that
photocopy you have to do it. So you want to show us the Railways Act, which provision?
20H plus 4.
20
H.
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 capital H4.
If any dispute arises out as to the apportionment of the amount or any part thereof, or to any person to whom the same or any part thereof is payable, the competent authority shall refer the dispute to the decision of the principal civil court of original jurisdiction, within the limits of whose jurisdiction the land is situated.
Where is your petition?
I am on petition, my lord, and that is the annexure, my lord, 5, my lord.
5.
5, my lord.
That is 31/2024.
My lord.
So what is your prayer in that petition?
My lord.
For reference. For reference.
Well.
So that is before Deputy CE.
My lord.
He is the authority.
My lord, he is the authority. He has the issued notice, my lord. Everything on his.
I am just enlightening my
And
lord.
till that they have not referred the matter, my lord. The amount has been
I am
determined.
just enlightening the court. Let the complete, I will enlighten the court.
Have
Mali,
have
here is the
got-
case.
uh,
According to his environment, let's see the annexure 6, page 20.
Yes.
In that notice, the competent authority has determined the share of the amount.
Oh.
Now this son is coming that
Okay.
I have a power of attorney, even though there is not probate, and she is claiming that entire amount should come to me. It is an interest dispute between the parties as regard to their share is concerned.
No, this amount has been already disbursed in favor of.
No, my lord, no.
No,
Then
that instruction
That
I
has
didn't
been
have.
determined. That has been determined. That I am claims on the basis of will of my father, my late father, that I am entitled to the entire amount, my lord. That is the lordship answer to
So
the my lord.
whether these people have the jurisdiction to decide that?
They are legal here, man.
They are the legal heir of the deceased
People, lordship,
father.
allow me 1 minute. I am the one of the son, my lord. The other two brother and sisters, my lord. My father has given a will that will decide in the civil court. That only my prayer before lordship and lordship that refer the matter to civil court. The civil court will decide. The central the railway authority has no role, my lord. He has deposited the amount. That amount will distribute among the whether I am entitled to the entire amount or the legal heir will get the amount. That will be decided in the civil court.
No.
The authority has no location to say here.
You suppose
My lord.
Your father has got 5 sons, right?
My lord.
And the father's property has been taken.
My lord.
So the normal circumstances they have determined, and it is to be equally distributed,
My lord.
right?
My lord.
You say that there is a will,
Will.
and your father has given the entire property to you,
My lord.
so the entire amount is to be paid.
My lord.
The question is that if there is a will, and your father is dead in the meantime, whether that requires that after the probate such claim can be made, or at any stage you can just on the
But that as per the statute, the matter, the only the authority to refer the matter to the civil court.
No, sir. Try to understand whether the will is required to be probated. That if that is there, then this authority have no right. You have to go independent of this. You have to declare the will to be probated if it is not a scheduled area. If it is a scheduled area, then probation is not necessary.
That is not a scheduled area.
It is scheduled area.
No. That's Sudan. This is not a scheduled area.
So you have to declare the will to be probated.
Otherwise, you see, the other sons may appear and raise objection that this will has been obtained in a fraudulent manner. The signature is not genuine. The father was not in a capacity.
That will be decided in this.
That is the why. So you are now taking away. You are trying to take away the claim of the others.
Unless the civil court pass an order, my lord, that amount I cannot take.
How the civil court will pass the order
Well,
unless your claim is basing Entire thing
that
is basing on
that will be decided in the civil court, my lord. That will be in the decided in the civil court, my lord. Whether I am entitled that I am
it will be referred to which court?
by the civil court, civil judge senior division, my lord.
Whether they are this will thing can be determined or it will be decided by the district judge. A will probate case codified habo.
Probate court district judge, the civil court that it is.
সেটা হেলা পরে হবে না, that has to be probated first. Means
That's what
the
civil court
authenticity of the will has to be tested in a court.
That
Once that authenticity of the will is tested, then you have a right, you can say that my matter will, because I have entitled.
And there must be a provision also. Suppose they, in the meantime, so let us say it is divided by 5, and it is also given to them. But ultimately, you succeed, and the will is probated, and it goes in your favor.
Let's you know how difficult to recover that amount. That is
difficult is not the procedure.
But, how can the entire amount be?
You are correct, but there is a procedure.
As per the will nama, I am entitled, man. If that.
Speaking to the same thing. By the way, why is there any development or it is lying as such?
It is lying as such. My instruction is
2024. It was Mr. Pari. You can say also this. It was this petition was filed under 20S4 on January 2024, and we are in November. So either you do it or make some response to why the man is has come to.
Let's keep it after 2 weeks. I will take the instruction.
That is the reason why so many writ petitions are being filed. Disposal of the representation. ଯାହା ହବ ଏ କରିଦେଇ ଚାଲି ଯାଆନ୍ତୁ।
ସେଟା କରିଦେଇଥିଲେ ସେ ବି ଯାଇଥାନ୍ତେ କି କଣ କରିଥାନ୍ତେ ସେ ଜାଣି।
ଲେଖନ୍ତୁ
Can I pray one thing?
Yes.
If a lord say direct to dispose the representation within a stipulated time, so that till that period not to disburse that amount. That matter can
not disburse koruna.
Might have been
that my instruction till today morning they have not disbursed that amount. Today morning we lordship record my submission. Let's till today morning I have got instruction.
WPC number so and so. The petitioner Niladri Singh alias Niladri Singh has filed this writ petition with a prayer for a direction to the opposite party number 2 to refer the case of the petitioner in respect of so and so to the civil court for proper apportionment of the case. The Land Council for the petitioner submits that a petition under section 20H of the Railway Amendment Act 2008 এটা তো যেটা আমাকে দেখাইলে এটা
20 capital H4
যে এটা তো Railways Act
1989
তারপরে এইটা কোড
amended 2008 না কোন amended act 2008
amended act সে তো নোট
কোড পাইলে
ନା ନା ସେଗୁଡା ଯୋଉ ପିଟିସନ ଟା ଦେଇଛନ୍ତି ସେଟା ଆମେଣ୍ଡମେଣ୍ଟ ହେଇଛି 2008
ନା ଆପଣ ଏମିତି କିଛି ତ ନାହିଁ ନା ବର୍ତ୍ତମାନ Railways Act ଅଛି
1989
ଏବଂ ତାର 20H ର ଆପଣ ଯୋଉ ପ୍ରୋଭିଜନ କରୁଛନ୍ତି that is there but your petition has been
mention that 28 ମାନେ that is
20H4 of the ଖାଲି ଲେଖନ୍ତୁ Railways Act 1989 for referring the matter to the civil court for its proper adjudication. It is the contention of the Land Council for the
amended act to notice railway notice amended act 2008 amendment act 2008
Railway Amendment Act 2003 the Land Council for the petition submits that even though more than 10 months have already passed. The petitioner has got no response from say the opposite party number kete
2
opposite party number 2 and his case has not been referred to the competent civil court for adjudication. The Mr. Pari and then Deputy Solicitor General of India along with another cover Mr. Pari.
Unmute.
Deepak Gochat.
मैं उसी कहबे ना कि उतना बार तो तीन
Yes, my lord.
ना रहिबो आपनको सेंट्रल गवर्नमेंट काउंसिल
We Guchat, D Guchat,
Mr.
Deepak Guchat.
Submits 2 weeks time to obtain instructions relating to the status of annexure 5. Put up this matter.
ସବୁ ବାଛି ଦେଇକି ଆସୁଛନ୍ତି
Information from also 2 तारीख ଆସିବ 2nd of December 2024. Yes.
Till that period not to disburse that amount. That's it. Till that period not to disburse that amount.
Item 9.
Yeah, please, Your Lordship. The petitioner has challenged illegal unlawful action of the opposite parties for construction of the drain without complying to process of law. What happened? The present petition landowner, their land is situated by the side of the Ranitwa Savang Road mill. They are the existing of 30 feet road. Out of 30 feet, they have widened the road 27, and the rest 3 foot. Out of 3 foot, 1 foot, 1.5 each in both the sides. Now they are constructing the road for 11. They are constructing the drain by encroaching the land of the 5%.
Representation.
Right. Answer 6.
Kindly have glance to
Yes.
annexure 6. Relevant person. ଏହି ଜାଗା ଆଗରେ ଉପରେ ଆଗାମୀ ଦିନରେ ଡ୍ରେନ୍ ହବାର ଆଶଙ୍କା ଜାଣି ଆମେ ଆପଣଙ୍କୁ ଜଣାଉଛୁ. Apprehending the construction of
8-10 ରେ ମାପ କରିଛନ୍ତି they have given the
representation file କରିଛନ୍ତି annexure 6.
have given the sketch map ଦେଇଛି.
Item 10.
My lord, this is a case under the NH Act, National Highway. My lord, I pray for higher compensation.
My lord, ଦବାର କିଛି proof ନାହିଁ. There is no proof of
Because
representation
in case it is filed.
my lord,
In the event any such representation has been filed.
Representation is pending which has not been disclosed, some shall be considered. Yes, next.
Item 11.
My lord, item 14 same.
14 million also same.
14 same.
Item 14.
14 same, already disposed of representation. Yes, next.
Item 11.
Hey, please, Lordship. 13-4 notice is under challenge, and I file a representation before the copy number 3, page 21, to regularize my account, and some time can be granted to represent the amount.
Notice representation will not do. You have to go to DRT.
I ready to deposit some amount so that till the representation dispose of.
But I am appearing for the opposite party.
The update on alternative remedy available. So it goes up. Yes.
May I pray, my lord?
Yes.
I will ready to deposit some amount.
Go there. Will not.
My representation also
Item
pending,
12.
my lord. Representation can be considered, my lord.
That's not maintainable.
May I please, Your Lordship? My lord, petitioner's agricultural land is acquired by the NHI for construction of the national highway. Thereafter, NHI directs land acquisition officer Jaspur for
Annexure 8 series.
Annexure 8 my representation. My lord, IA is there for stay of notice because
Dispose of annexure 8 to be disposed of within time limit. Result to be completed. Next.
IA is there for stay of notice. Already petitioner not.
Let's see item 13 on behalf of Mr. Mohanty.
joining in government panel. 1 week time to appear some other council.
कौन आदि प्रेयर थिला रिप्रेजेंटेशन तो आउ कौन रिप्रेजेंटेशन डिस्पोज ऑफ हिजो आपन ना लिख दो तो आपन देखो नाटा
Chandrasekhar Mandal.
representation disposal of. Yes, next.
Item 15.
Challenging the matter preventive detention notice under Annex 1 matter. Page 12. Under Section 3 of the Prevention of Illicit Traffic in Narcotic Drugs and Psychoactive Substance Act 1988.
Minors 711. Oh, he is in the advisory board. Justice Sinha
They are listed before the division bench, and since the Justice Sinha was the chairman of the
advisory board, something will be no,
Chairman of the state advisory board. I want so joint secretary one of the bonds so that is for the support preventing him from engaging excessively power and decisions forms. I started that songs we detain and equipment for him. So on what ground you are challenging this?
I am challenging, but the grounds of detention, my lord, under Annex 2, page 13, they have stated that the petitioner is involved in 4 cases. And the last prejudicial.
They supplied you the grounds.
Yes, madam.
With the FIR.
Yes, madam.
Then you, what you did?
Well, my submission is. So the Annex
after receipt of these grounds and what you have done?
The challenge, madam.
No.
Whether he has submitted representation?
You must have you have to file your representation that this ground is not proper. Then that is to be considered. It's not that after. So right, even the paragraph 9 you Akhtar Khan have a right to represent against your detention to the detaining authority, to the central government, as well as to the advisory board. If you wish to avail the right, you should send your representation through jail authorities where you are detained in the manner below. If they in the representation এবং they are to individually take into account, right? ତେଣୁ ଆପଣ ଏଇ ଯୋଉ ପାଇଲା ପରେ we are putting you a straight questions that have you submitted any representation?
No, madam.
This petition has been filed with a prayer for quashing Annex 1, which is the order passed by so in exercise of the power under Section 3(1) of the Prevention of Illicit Traffic in Narcotic Drug and Psychotropic Substance Act 1988, in directing the petitioner to be detained and kept in special subjail Deoghar, Odisha. It appears that the said order is accompanied with the grounds of detention. And in the grounds of detention, it is specifically mentioned in paragraph number 9 that the petitioner has a right to represent against his detention to the detaining authority, to the central government, as well as to the advisory board. And if he wishes to avail this right, he should send the representation through the jail authorities where he is detained in the manner indicated in the said grounds. Land Council for the petitioner submitted that no representation has been made by the petitioner to any of the authorities as specified in the grounds under Annex 2. And therefore, he seeks permission to withdraw this petition to file the representations before the appropriate authorities. Permission is granted, writ petition is accordingly disposed of. Yes, next.
Your Lordship, I am appearing for all the opposite.
Mr. Dipti Ranjan Bhokta.
Along with Learned DAG. Along with Learned DAG.
Mr. Party and Deputy Solicitor General. Yes, next.
Item 16.
Amendments, Mr.
Some additional grounds. This writ petition is directed against the order of the DR80, wherein the appeal has not been entertained and dismissed on the grounds of delay by the petitioner in filing the appeal. DR80 has dismissed the appeal. So, without condoning delay. So,
that you have challenged.
That I have challenged the writ petition. Now, some additional grounds also have taken.
Okay.
By way of this amendment.
Enter appearance here that Punjab National Bank.
Yesterday, I think somebody was there.
Manoj Kumar Mahapatra na lekhai.
Se kali mate କହୁଥିଲେ ଯେ ମୁଁ ଗୋଟେ formal objection ଦେବି ବୋଲି.
କଣ କରିବା ପାସ୍ ଓଭର କରିବା ନା ଆଉ ଗୋଟେ ଡେଟ୍ କୁ ରଖିବା
କାଲି କି ଥାଉ ରୋଲ ଓଭର କରୁ
ତାଙ୍କ ନାଁ କେମିତି ଆସିଲା ସେ ନିଜେ ଆସି କହିଲେ ନା କଣ ନା
ମତେ କାଲି ଦେଖାଇଥିଲେ
name appears in our list.
Name is there in the list. That is why we say how that name came in.
No, he has appeared. In fact, he requested me. He was talking to me yesterday.
He appeared on 7/12.
Sure. The IA for amendment, Mr. Gautam Mukherjee and senior advocate is present. None appears for the opposite party bank. Will this matter next week?
It is appearing.
The opposite party is at liberty to file objection to the interim application by the next date. All right.
Item 17.
May I please, Lordship? Lordship, here, my lords, an IA has been filed seeking just my lord's protection till next date of listing. My lord, notice has been issued. It is posted on my lord's week commencing 25th.
In this case, I have instruction to appear on behalf of the bank. And your Lordship has passed an order. He has passed, filed this review because your Lordship had directed to the collector and district magistrate to act upon the order passed under section 14 of the Surface Act. Since 2021, order under the Surface Act has been passed. Since they are not, the Tahsildar is not cooperating. Though the date has been fixed, police personnel has been deputed. For that reason, your Lordship has been directed to consider our representation.
Where is that order?
Annexure 1, Lordship.
I have instruction to appear. They have served a copy on me yesterday only.
Yes.
I have prepared my objection, but I have not gone through this.
IA number 408 of 2024. Which application he has filed?
Review petition 259 of 2024.
You have filed the review petition.
No. I have.
Yes.
Review petition number so and so. The
259 of 24.
Mr. A.K. Biswal, Land Council submits that he has instruction kariba.
Yes. Today I will file.
He has instruction to appear for the opposite party, Punjab National Bank. Opposite party number 1. And he will file his Binama to also the objection
in course of the day.
Review petition in course of the day, serving a copy of the Land Council for the petition. Is this matter next week?
Yes, next week.
Lordship, protection till next date, my lord. That is, my lord.
See that.
Item 18.
Name of the petition is not potentially typed as one.
My name may be reflected in the cause dispatch.
Such a cause, Mr. Biswal's name be reflected in the cause. Then, the name of the petitioner has been found in Habagata. Typed as Horace Chandra, who the lead head of.
Horace Chandra. Chandra है first Horace Chandra.
Chandra, वो जरा Chandra होगा. अच्छा. Read out further होगा ना. the it has been pointed out by the dealing assistant. The dealing assistant pointed out that in the order number 1 dated 5/11/2024, the name of the petitioner has been inadvertently typed as Horace Chamdo Mudili, instead of Horace Chandra Mudili. The in the top of the order, the name of the petitioner shall be read as in the order dated so also shall be read as Horace Chandra Mudili in place of Horace. Yes.
Item 19.
Your Lordship, by order dated 28/10 to 2024, I was directed to take instruction whether any appeal has been filed. Departmental appeal has been filed by the petitioner, but he has not filed departmental appeal. No, my lord, I will make my submission, my lord. Let it come up to 1 week. I am not well today, so I will make submission because my lord, availability of
petitioner, Mr. Das, submits that he is not well and the matter may be taken up a week after. This matter because also there's next.
Item 20.
Come up after 1 week. Yes.
obligement.
Yes, item 20.
The other day I had placed the impugned judgment, my lord, but I was going to place the counter filed by the
Clearing for the other side.
Mr. Asif.
Yes.
So it is that matter the Lordship kindly see impugned judgment.
Why it was kept today?
Actually, my brief was not clear in accordance with the Lordship's brief.
Pagination.
That is the reason of pagination. No, pagination is that there is no pagination but flag B. Now we have we have taken the
Pen drive might have
pen drive. We have taken the pen drive and found out that it is not paginated, but it is at flag B. Counter is at flag B. The impugned judgment or Lordship impugned judgment for Lordship to recapture Lordship's memory. The petitioner is the assistant professor.
You are challenging the order judgment dated 5/5/2017.
No, my lord. I'm challenging yes, 5/5/2017. I'm sorry, 5/5/2017.
5/5/2017.
My lord.
Passed by the London single judge in WPC number 15499 of
Yes, yes.
right.
Yes, my
Let
lord.
us come to that order first.
Yes, my lord. My lord. That is at page what 34. Sorry, 38 and they pointed to place it, my lord. Because
just you place the first paragraph.
First paragraph, right?
Just we want to know that what is the prayer of that.
My lord.
Just Mr. We are just coming within 2 minutes.
Oh, yes, my lord.
Yes.
Page 38, my lord.
Just read the first paragraph.
The petitioner, having stood fast in BB Science and the Age, was conducted in the year 1989 by the OUAT and completed her MB Science in first division in the year 1992. The subject veterinary bacteriology, virology by following due process of selection was initially appointed as senior assistant under the OUAT in the scale of pay of so against the post of junior scientist at Moisapat by office order taken so. While she was so continuing, she qualified in the NET in 1994 on 24/7/1993. Partial modification of the order dated 9/7/93. Petitioner was posted as research assistant against the post of junior scientist and was reposted as such against the post of lecturer bacteriology ISS plan Orissa Veterinary College. On 12/6/1985, the petitioner filed a representation before the registrar OUT to be appointed as ad hoc lecturer since she acquired the minimum qualification and had been holding the post. Pursuant to the query made by the registrar OUT, the Dean of the Veterinary Science and Animal Husbandry OUT by letter dated 5/10/2000, 1995, by pointing out that the petition had been adjusted against the post of lecturer, requested for publication of advertisement to fill up the vacant post as per the list appended to the said letter. As no steps are taken for recruitment against the vacant post of lecturer, the Dean of the Veterinary Science and Animal Husbandry OUT issued a reminder to Register OUT to take steps for recruitment and file stating so specifically pointed out that the petitioner who was appointed as research assistant has been adjusted against the post of lecturer. The petitioner, referring to her earlier representation dated 3/6/1995, again filed a representation on 21/7/96 to consider case for appointment as lecturer. In the said representation, she stated that though she had already rendered 3 years of service as lecturer and was also continuing as such, her case for appointment as lecturer had not been considered, nor the post had been advertised. Even though the other disciplines advertisement have been made by the authority and the research assistant working in the other faculties had already been appointed as lecturer in the concerned department, by letter dated 5/8/1996, the Dean of the Veterinary Science and Animal Husbandry OUT, while forwarding the representation of the petitioner to the registrar, OUT specifically indicated that there were two vacancies in the rank of assistant professor, one post plan and another non plan in the Department of Bacteriology, and action to be taken to fill up the post so that petitioner could be adjusted. The petitioner again made a representation on 27/1998 to consider her case for regularization in the post assistant professor, since persons below her in the select list had been adjusted in their respective departments as assistant professor. Due to inaction of authority, petitioner approached this court by filing OJC number so and so, which was disposed of by order dated 28/1/23, sorry, 2003, with direction to direction the as and when petition appointment and filling of post lecture bacteriology would be considered by the university. It would also consider the case of the petitioner, keeping in view the academic qualification, the NET certificate, and the experience in accordance with statute. Thereafter, an advertisement was issued for the post assistant professor bacteriology in the College of Veterinary Science and Animal Husbandry (OUT). Person selected and appointed as assistant professor bacteriology as per letter dated 12/10/2005. While so continuing, she made a grievance that she should be extended with the benefit from the date of initial appointment, that is 31/7/93, as to enable her to get senior scale of pay with effect of 1/8/2001. But the implementation of the petition was not considered for a long period. Ultimately, on 29/2008, the same was rejected, since the application has been filed seeking for direction to the opportunity to treat the petitioner as lecturer, public assistant professor, except from 31/7/93, the grand scale of pay of consequential for his benefits and financial pay as due and admissible to the post
Okay,
to the
so
post of the
that is your basically prayer. So
basically prayer.
what has been held?
My lord, my lord, dear Lord, kindly the then dear Lord, kindly. Uh,
What is the observation of this court?
Observation, I am just reading. My lord, para 7.
Para 7.
Para 7.
Yeah.
Para 7. The relief claimed. The relief claimed in this writ petition rests on the fact that the petitioner, having been appointed research assistant, training assistant under the different scheme of the OET in the scale of pay of so and so, with usual allowance having been allowed to continue against the vacant post lecturer, is entitled to get the benefit of teaching experience and continuity in service against the post assistant professor of bacteriology and virology in the veterinary college. There is no dispute that there are two sources of recruitment, namely recruitment to the post of research assistant, training assistant, which is a class 3 post, and recruitment to the post of assistant professor, which is a class 2 post. Admittedly, the petitioner had been selected for the post of research assistant, training assistant, person to which he joined on 31/7/93. Against the class 3 post, officially she was posted as junior assistant in Moisapad. On her request, she was adjusted against the post of lecturer and veterinary science college OUT, where she had been discharging her duty.
That is a paper.
So officially she was posted as junior assistant on her own request. That is actually we have not made any request. The honorable court has said on her own request, but there is no such thing like our own request. Anyhow, she was adjusted against the post of lecturer in veterinary science college, whereas she had been discharging her duty. That issue factor may not entitle her to get the benefit of teaching experience as well as the continuity in service in lecturer oblique assistant professor from the date of joining as research assistant training assistant with 31/7/93. The bone of contention of the learned counsel for the petitioner is that, as per the provisions contained in Statute 49, as she had been discharging her duties from 31/7/93 as lecturer, she would be entitled to senior scale of pay with effect from 1/8/2001. Statute 49 of the University of Technology reads as follows. Whenever a permanent post in any grade and pay scale is available for substantive appointment, the claim of any university employee holding a tenure post or temporary post continuously for a period exceeding 2 years in the grade and pay scale possessing the qualification required for the permanent post shall be considered first as substantive appointment in their permanent post. As a matter of fact, petitioner was posted as research assistant, which is a class 3 post with the state government scale of so and so against the vacant post of lecturer, bacteriology and College of Veterinary Science by the office order dated so and so, in which she joined on 31/7/93. There was no sanctioned post research assistant in the Department of Bacteriology and Virology, Veterinary Science and Animal Husbandry. Consequently, the petitioner was posted against the vacant post of lecturer bacteriology with a view to provide her employment and to assist the teaching in the department. She was not selected and joined as the lecturer in bacteriology and UGC scale of a so and so, and also did not hold the class 2 cadre post, having duly selected by selection committee as provided under class 3 1 Roman 2 of OUT statute 1966. Therefore, the petitioner having not joined in the same grade and same scale as assistant professor, the question of application of statute 49 doesn't arise. While the petitioner was continuing as research assistant, she availed the study leave for prosecuting PhD degree from 1/9/2000 to 29/2004, which was allowed or as applicable to non-teaching employees of the university as per decision of the Board of Management resolution dated so and so. And the person discharged the duty of research assistant, she was drawing the scale of her admission to the said post from 31/93 to 76/2005. The relief as sought for in the application having been considered by this court and added to writ petitions number so and so. The petitioner the following regularize the post of lecturer bacteriology in the veterinary college of opposite bed number 1, that is opposite bed number 3 from 37/93, and petitioner be given all emoluments attached to the post of lecturer 37/93 and other benefits as permissible under the law for the date of her joining as lecturer. This court disposed of the writ petition, writ application by the order dated 29/1/2003, directing that as and when the university considered the question of appointment of filling of the post of lecturer in bacteriology, it would also consider the case of the petitioner, keeping in view the academic qualification, the NET certificate, and experience in academic statute. Consequently, the advertisement was issued in the year 2005. The petitioner appeared before the standing selection committee, and on recommendation, she was appointed assistant professor bacteriology. She again filed WPC number so and so, seeking the benefits as were sought for in OJC number 13411 of 19. When the given to the petitioner has already been considered decided earlier, pursuant to the rest of this and all group, she has already been appointed and joined as assistant professor bacteriology. She has once again approached this court claiming continuity in service
from 31/93 till 17/3/2005 after her grievance was rejected by the authority. So exactly language has not been couched in the present application. Effectively, relief sought for is the same and similar to that of earlier two writ applications. In Pullal month versus in NESCO, the provision of funds or disposal of funds, a similar question came up had come up for consideration for this court. In that case, petitioner who had functioned as lineman A allowed to continue for some period to discharge his duty as junior engineer. On joining as junior engineer, he had again posted functioned as lineman A, claiming that he should be allowed to continue as junior engineer. The court declined to grant relief, such relief to the petitioner in that case. Applying the said analogy, the present case, since the petitioner admittedly joined against a class 3 post as discharge assistant by following due process of selection, merely because she was discharging duties in a vacant post of lecturer, which admittedly is a class 2 post. She cannot get the benefit of continuity service against the teaching post from the date of her joining as teacher assistant by the 31/7/93 till 17/3/2005, on which date she was regularized as assistant professor by following due procedure of selection as class 2 post of OUT, accordingly dismissed. My lord, at this stage, may I take your lordship to the writ petition, original writ petition?
Original, no? They shouldn't come.
I mean-
They have filed the contrary order of the
Okay.
flag B, flag B.
Flag B, sorry, flag B of the writ appeal.
Page 31. Page 31.
No, writ petition which
what do you
writ
want?
petition, my lord, two orders, my lord, two orders, my lord, can you see? ଏତେ ନଥିବ
କୋଉ ଅଛି?
ଯୋଉ ଦୁଇଟା ଆମେ ଚାରିଥର ଦେଖେଇଥିଲୁ ମୁଁ
Flag B ଟା ଅଛି।
ଅଛି ଅଛି
Flag B ଅଛି।
ନା ଫ୍ଲାଗ ବି ତ ଅଛି ନା ମୁଁ ରିପିଟିସନ ର ଦିଟା ଅର୍ଡର ଯୋଉଟା ଆପଏଣ୍ଟମେଣ୍ଟ
Appointment.
ଦିଟା ଯୋଉଟା ଅନ୍ our own request, that is not the case. Lordship will find that is
It was
writ
from the side
petition,
of
my
the
lord.
university.
Writ petition, if lordship can writ petition, out of which the
So it was done by the university, not
Yeah.
at your request.
it was done by I'm obliged, my lord. It was done by the university, and from the day one she was promoted, she was adjusted against, because as you know, there is no post of research assistant. Though she selected as research assistant, but there is no post of research assistant. So from the day one she has been acting against the vacant post of lecturer. That is there in the, my lord, page 25, annexed 2. Writ petition annexed 2, page 25.
Was she selected in ad hoc post? Because there were two posts according to your writ petition. One was in regular research assistant and the other one was ad hoc post.
No, there are said that two posts of lecturer. That he is saying that university has said that there are two posts of lecturer.
So
But
there was no post
27
for research assistant, but she was selected.
sorry, my lord.
There was no post for research assistant.
No, there is no post. As I found from the impugned judgment, my lord, there is no source for, but she was the page 27 or so can leak. Therefore, they modified it, modified the order of appointment.
So is the selection process for research assistant is the same as lecturer?
No, not same, not same, not same, not same. But lordship, so page 27 of the writ petition, lordship can leak, annex 3.
Right.
In partial modification, that is on 24/7/93, immediately after the my appointment. Partial modification of this office order dated 9/7/93. So Rajesh Mishra, the present petitioner, was posted as research assistant against the post of junior scientist. Insurance of his party is posted as against the post of lecturer of bacteriology, SS plan rule. And accordingly 31/7 I joined, and from that admittedly I have been continuing.
Never presented before the selection committee for this.
Yeah, sir.
Never.
No,
she never appeared before this
the selection committee, because she was appointed when as per the judgment, my lord, when they made the regular selection for the post of lecturer, I applied and got it in 2005 as a lecturer.
That is for the first time in 2005.
Yeah, because at that point of time there was no year. My lord,
but here the claim is for 1993 to 2005.
2005. My lord, at this stage, if a lordship will find from the
your writ petition, paragraph number 5.1.
1 minute, yes. 5.1.
Page 3.
Yes, ma'am. I'm sorry. 5.1, yeah, ma'am. May permitted. The petitioner, after passing MB Science OUT course and appeared in process of selection
Sorry.
Counter.
It is the repetition.
Original
That is
repetition.
there. That's come.
1549. Take it. Yes. Right.
Page number.
No, 154 line.
Page repetition.
Hmm.
Page 3. Page 3, paragraph number 1.
I one.
Please press now.
My lord,
5.1.
paragraph 5.1, that the petitioner, after passing her MBSc OUT, the course had appeared in process of selection as research assistant, training assistant in different schemes under the OUT in the scale of pay also with the usual allowance as they are sanctioned by the university from time to time. The petitioner in the process of selection conducted in 1993 stood fast and was given posting as research assistant against the post of junior scientist. Copy of the office order transfer is annexed to, which was modified subsequently. The next parallel also will see.
Research assistant.
Research assistant, that is admitted fact. That is a research assistant because on 24/7/93, the partial modification of the office order issued annexed to the petitioner was posted research assistant against the post of junior scientist, deposted as against the post of lecturer. SS plan, the copy of the office order is 24/7/93, which I was showing to your lordship. I was just placing your lordship the annex 3, page 27.
Annex 3, just a minute.
Annex 3, my lord. Page 27.
In partial modification of the office order one, so Rajashree Mishra was posted as research assistant against the post of junior scientist is reposted as such.
In the post of lecturer, and from that day onwards, I mean, admittedly there was a vacant post. The plea they had taken that at that point of time that there is a paucity of funds and all that they are not going for regular lecturer. I had the qualification also for the lecturer that has already been observed by honorable single judge Mellon. So Mellon, what happened, Mellon, that after at this stage the lordship kindly see the annexure B to the earlier judgment. Sorry, Mellon.
Assistant, somebody faced the selection process of a research assistant.
Mellon.
So the eligibility criteria of a research assistant and that of a lecturer will be different.
Different. But for lecturer, any qualification is a must.
No. We are just wanting to know that somebody has been faced the interview or selection process of a research assistant. So can he be posted immediately, not as a research assistant and as a lecturer?
Because he had the qualification to be a lecturer.
But if a post of lecturer would have been advertised, then more brilliant candidates might have come to apply for that.
No, that is one part, my lord. That is one part. But they have stated, the university has stated in their case, my lord, that because of paucity of funds, they did not go for advertisement. And I had the qualification for the year. And not only that, I have been
no, because you are claiming your thing from this 93. Yes. That is why we want to see whether this is legally sustainable or not. So they have done it. It's all right. But whether somebody who has faced the selection process of a research assistant can be posted as in the post of a lecturer when the post of lecturer has not been advertised. And you are claiming your benefits.
Yes, my lord.
That date 93.
Yes, my lord. That is my lord. And I'll cite a dozen, my lord, of the Honorable Supreme Court exactly in similar circumstance. Honorable Supreme Court said that if it is a time gap arrangement is a continuous, then they will be entitled to all the benefits. That is a different. That I'll cite subsequently, my lord.
Claiming is that the salary of this assistant professor or something like that from 93.
93, right.
93, you are never posted as a assistant professor. You are posted as a lecturer.
As a lecturer.
Even if we accept that on 24/7/93, you are posted as a lecturer. So how can you get the salary of an assistant professor from...
assistant professor, lecturer, same. Only redesignated assistant professor. Lecturer is redesignated assistant professor. So category is same. Previously it was lecturer, reader, professor.
So, Mr. Counsel for the OUAT, the lecturer and assistant professor same and same salary.
Previously it was called lecturer, reader and professor. Subsequently it has been assistant professor, associate professor and a professor. So that only redesignation. As per the UGC guidelines, my lord, only redesignation. Nothing more than that.
Nothing more than that. And admittedly, continuously from that day onwards, they have been. My lord, and you have mentioned in your writ petition that the scale of fee is same, or the OUT has mentioned. No, something has to be pleaded that because if we see that the doubt is cropped up in our mind that somebody is discharging his duty as a lecturer in bacteriology in 93, and he was we can say he was promoted or something like that as the assistant professor. No, not promoted. That is the same cadre. Only redesignation. Only redesignation. No question of professor. As per the UGC guideline, my lord, lecturers are treated as assistant professor, readers are treated as assistant professors, and professors are professors. That only redesignation. There is no
So
question
the
of
only
promotion.
difference is the process of selection.
That the
For the post of lecturer and
promotion, my
researcher.
lord. Previously, it was known as lecturer, reader, and professor.
Advertisement.
Now it is as per UGC guidelines. Council say that whether the process of selection of research assistant and process of selection of lecturer is same.
No, different. It's a class 3 post.
Yeah.
Research assistant is a class 3 cadre post.
Yeah.
And the post of lecturer, and that is assistant professor, is a class 2 cadre post. The method of selection are totally different.
So whether at that point of time when this man was reposted as lecturer,
He posted. He was not appointed. There was no regular post of research assistant.
Whether that post was lying vacant.
Lecturer post was lying vacant. Yes. But that is why he has got the qualification. I don't dispute that. Therefore, he made a representation time and again to make a issue advertisement so that he can be appointed as a lecturer in a class 2 cadre post, not class 3 cadre post. That is why, since her representation was not considered, he approached this honorable in the writ petition. In that order, I will show your lordship, that is the main order. The same issue has already been decided. So the same issue, she was satisfied with that order because he did not challenge that order. They passed by this honorable court. She waited till 2005. A notification was issued for appointment of lecturer. She applied and got selected to the post of lecturer in 2005. When the post of professor was advertised and she found that he doesn't possess the required year of experience, he again made a representation before the authority that to count
that period has to be counted.
So here what I submit, Miller, is if the principle of res judicata will apply. Otherwise, there will be no end to the litigation. Again, we will make a representation and come here. I will, you know, see that is the clear. I am placing the judgment.
That is, I was showing the counter melody on counter flag B, that judgment which they are saying that flag B melody, page 31. So that means what you want to say, in the due process of selection, he was selected
in 2005
as a lecturer in 2005.
Yes.
Right. So prior to that, it was just a posting in that.
Yes, just to since there was
adjustment
research assistant on her own request, Miller, her husband was working at Bhubaneswar. So that there is no document. Just I'm placing since this stand was taken in the counter. Since her husband was working at Bhubaneswar, he requested to post her at Bhubaneswar. He was posted against a post of lecturer for drawing of salary only. Therefore, she continued there. He discharged duty not as
the salary he was drawing of
was research
on the own scale of it.
Research assistant. So getting the scale of research
and
assistant.
that is how she also availed the benefit of research assistant to go for PhD. Go for PhD. That is for non-teaching staff.
Yes.
That she availed.
Yes. So your lordship may see that judgment, Miller. That is very clear. Therefore,
I'm placing that page 31, Miller. 31. Page 31, flag B. Yes. 21/2003. It's a small judgment. I can place the entire judgment. It's a small judgment.
Yes, 31.
But you got it, man. Yes, sir.
The petitioner was appointed temporarily as a research assistant against the vacant post of junior scientist HARP 2 by order dated 9793 and Vice Chancellor OUT. However, by order dated 24/7/93, her appointment as the research assistant was shown against the post of lecturer bacteriology, PSS plan of Orissa Veterinary College. The grievance of the petitioner is that since she is continuing as against the vacant post lecturer since 1993 and is duly qualified to hold the said post lecturer without any reason or rhyme. The said post is not being filled up by OUT to fill up to keep her out of the job. The contention of D.S. Mishra, the Learned Counsel, is that the normal cause of event, the vacant post are advertised by the university and filled up by selecting suitably against candidates with requisite qualification and experience. The prisoner is a master degree holder and in subject and duly qualified to hold the post of and in addition, she has qualified in the NET National Eligibility Test for lecturers, has been taking classes both theory and practical and performing the duties of assistant professor in bacteriology and virology, but the opposite party they are not advertising the post to fill up, nor she is regularized in this post. According to this learned council, since she is appointed against the vacant post of lecturer, duly qualified to hold the post, she has been taking classes. She should be regularized in the said post, given the emoluments attached to the post since 1996 July. The OUT opposite party number 4 has filed a counter denying the allegations and the claim made in the petition. It is their specific stand that as per the UGC norms, the post of professor, associate professor and reader, associate post oblique reader and assistant professor oblique lecturer are filled up through all India advertisement and on recommendation by a statutory selection committee. The petitioner was never appointed as an ad hoc lecturer or regular lecturer pursuant to any advertisement on selection through the statutory selection committee, but she was appointed as a research assistant, which is the class 3 cadre post against the post of junior scientist, animal nutrition and with Mohisapat and on a request to come to Bhubaneswar, which while her husband was working. She was posted in the scale up so against the vacant post of lecturer, actually was a university, but not a lecturer. The dear Dora Loan Council for the opposite party, OUT submits that the petitioner having never been appointed a lecturer in the process of selection, though through open advertisement and recommended by statutory selection committee and having been appointed only as a research assistant, question of regulation of observation in the vacant post doesn't arise. Further, due to financial crunch, the post is not being filled up and as such, the advertisement was required to be made. In view of the submissions made as per the bar and pleadings of the parties, it appears that the petitioner was appointed a research assistant by the state university initially as against the vacant post of junior assistant NARP Mysapat, but subsequently posted as such against the vacant post of lecturer bacteriology in a veterinary college. Undisputably, she was not appointed as a lecturer as such, but petitioner has the requisite qualification has been cleared national eligibility test for lecturer. There is vacant post of lecturer in the subject, and a post of lecturer can be filled up through All India Open Advertisement on the recommendation of the statutory selection committee. But this, for the moment, the post is not being filled up due to financial crunch. In such view of the matter, the writ application is disposed of with the direction that as and when vacant industry opposite number 1 considers the question of appointment and filling of the post of lecturer and bacteriology, it shall be it shall also consider the case of the petitioner, keeping in view the academic qualification, the NET certificate, and the experience in accordance with the statute, the project for communication of the object part to be filled up. Your Lordship may kindly see at this stage, may take your Lordship to judgment of the Honorable Supreme Court. I'll say on my question reserved, I will answer, my Lord. Your Lordship may kindly see. In the similar case, my Lord. That is 2013 volume 4 SCC 152.
So that means the prayer which you made at the earlier stage, that was torn down.
No, that was
Yes,
And
that.
that is being stated that
Yes, my lord, that is being examined.
down, and you have not approached the higher forum.
No, my lord,
Then,
I am just answering
how
that
do
issue.
you again claim the self-same relief
No, not
which has
actually.
been refused in the
Actually, Lordship, kindly see, my present repetition claim is as per the statute 49. As per statute 49. And the statute 49, my lord, categorically provides that on completion of 2 years, the person will be deemed to be clear. That statute 49.
statute 49 was not there when you made that repetition.
No, statute 49 was there, my lord. No, not that it was there at that point of time.
Piecemeal submission
that
at that stage that was available to you, you have not taken that.
My lord, statute 49 is there, but my humble submission or lordship will see. Because in that case, that was actually not simply their lordships are categorically held that it should be fresh selection will be made and she can be appointed against the fresh selection if at all.
you had the prayer.
That is there, my lord.
You had
My lord,
the prayer to give you the
my lord, only by statute.
99.
Statute, because here, my lord, the lordship kindly see the para 2 of the judgment by kindly see. On being selected by the West Bengal Public Service Commission, the appellants were appointed as Assistant Child Development Project Officer in 86-87. After about 12 years, the competent authority issued an order dated 7/19 and concurrence of Finance Department. The government, whereby the petitioners were temporarily transferred to ICDS project to act as CDPOs in their existing pay skills. The appellants made representation 15 to 2011 with prayer to they may be promoted to the post of CDPO or given pay scale of that post by asserting that they had been discharging the duties of the CDPO and that sorry, my lord.
Ratio is what? It comes to the it's not that. What is the ratio? Because the fact.
My lord, you will also kindly see. Not only who knows the facts, but how facts are akin. My lord, para 13.
Yeah.
Para 13. Sorry. Reverting to the facts of this case, we find that although the appellants were recruited as CDPOs, the state government transferred and posted them to work as CDPOs in ICDS project. If this should have been a stopgap arrangement for a few months or the appellants had been given additional charge of the post of CDPO for a fixed period, they would have been legitimately claimed salary in the scale of pay of higher post, that is CDPO. However, the fact of the matter is that on the date of filing of original application before the tribunal, the appellants had continuously worked as CDPOs for almost 4 years, and as on that date filing of the petition, they had worked on the higher post for about 6 years. By now, they have worked as CDPO for almost 14 years and discharged the duties of the higher post. It is neither pleaded in the case of the respondent nor had material been produced before this court to show that appellants had not been discharging duties of the post of CDPOs or the degrees of their responsibility is different from the other CDPOs. Rather, they have tacitly admitted that appellants were working as full-fledged CDPOs since July 99. Therefore, there was no legal or other justification denying them salary and allowances to the post of CDPO, and the petitions that they have not been promoted in accordance with the rules. The convening of the promotion committee or taking other steps by filling of the post of CDPO, the promotion is not in the control of the appellant. Therefore, they cannot be penalized for the government's failure to undertake exercise of making regular promotion. In the result, the appeal is allowed. Input order is set as one passed by the tribunal set aside.
In that case, the recruitment was made for
SCDO, assistant, but they were assistant chief child development officer.
Right, and they were posted as
CDPO promotional post, higher post chief child development project officer. That is they posted as so they worked there for by the time they had come to the court, it was 4 years. Subsequently, at the time when matter is placed before the Honorable Supreme Court, it was 6 years. So that and they were continuously working for against that post. And that is the reason the Honorable High Court had rejected their prayer, and Honorable Supreme Court set aside that prayer and said that since it is not a sorry,
that was in tribunal.
Tribunal thereafter High Court. Thereafter, thereafter High Court. Well, and since there is we got a stopgap arrangement that for term, as has been held by the Honorable Single Judge judgment, which was a stopgap arrangement because he was for some time was working as junior engineer. Again, after junior engineer came, he was reposted as lineman A. That is the reason why that judgment will have no application to the present case, my lord. My lord, kindly see. And here, my lord, the claim is based on Rule 40. Had there not been, sorry, my lord.
Just clarify
Sorry.
that the case which you are placing
My lord.
the recruitment of that
Para two, my lord. Para two, lord.
acting child development project officer.
Yes.
And the CDPO.
Assistant Child Development Project Officer in the para two, my lord. Assistant Child Development Project Officer in 86-87 after 12 years of competent authority issued an order 7/19 after concurrence of the finance department. Para two. Fact para two. It's a factor. Para two.
Right.
On being selected by the West Bengal Public Service Commission, the appellants were appointed Assistant Child Development Project Officer in 86-87. After 12 years, the appointing authority issued an order dated 7/19 with the concurrence of the Finance Department. The government helpful practitioner temporarily transferred to ICDS project to act as.
Can a lecturer lecture post is the promotional post of a research assistant?
No. Not a promotion post of lecturer. Not a promotion post of lecturer. It is a separate. No, my humble submission only for the limited purpose of the CDPO, my lord, when they are asked to act as CDPO for about more than 6 years. That is the reason the Honorable Supreme Court says that it is not a time gap arrangement, it is a regular posting. So they feel entitled to the salary and all emoluments to the CDPO. That is para 2 and 3 is very clear. And there is a problem. The appellants were represented and with whether they were maybe promoted to the post of the given pay scale of that by asserting that they had been discharging the duties of the post of CDPO. Yeah. And to that, my lord, para 13, my lord, Honorable Supreme Court.
Anything else, Mr.
So, my lord, what does my lord, dear lordship, may I take a lordship to statute 49 again? And another judgment of Honorable Single Judge, the same Honorable Single Judge, in that case also the petitioner was acting as research assistant, thereafter was working as against the postal lecturer, and there also she was but honorable civil relying on statute 49 categorically held that no he is entitled to that. My lord, I am just
have you mentioned anywhere that quoted
that is no single judge also
single judge. That is quoted. You just 49 paragraph.
Then that honorable single judge
quoted question the quote.
My lord, copy
49
page के judgment
dear lordship, kindly. Though it is a single honorable single, but it can be for the purpose of purchase.
Page 46 मिला
page 46.
Towards the bottom मिला.
Just.
Statute 14. Whenever a permanent post in any grade scale is available for substantive appointment, the claim of any university employee holding a tenure post of temporary post continuously for a period exceeding 2 years in the grade and pay scale and possessing the qualifications required for the permanent post shall be considered for and substantive appointment in that format. So it implies that first starting with the same grade scale pay. When that means the grade scale of pay of a class 2 cadre post. But he was not temporarily or not in the post of class 2 cadre. That is also clarified.
Yes.
As a matter of fact, the petition was just page 47. As a matter of fact, the petition was class 3 post with the state government scale of pay 1640 to 2900 against a vacant post of lecturer of bacteriology in the College of Veterinary Science by the officer of dated so and so in which he joined on 31,793. There was no
Reason to check.
Department of
Nine.
College of Veterinary Science and Animal Husbandry. Consequentially, the petitioner is posted against the vacant post of lecturer of bachelor, which is used to provide your employment and assist the teaching in department. He was not selected and joined as lecturer in the bacteriology. This is scale of pay.
But there is some fault with you also. If there was no such post,
why did you go
assistant, why did you go for advertisement?
That means it was intended that he should be taken and again taken to this.
Him as, so he has discharged his duty. That you cannot say that entire blame on the petitioner.
No, I'm not saying that. But
it was your advertisement, and he was posted as one. So, and now you admittedly there was no sanction.
Research assistant post was not at Bhubaneswar.
The him as in the post of lecturer, you allowed to discharge his duty. Of course, he has not taken given that salary of that lecturer, but he was drawing the that what has been sanctioned for a research assistant. So these are the
Honorable Single Judge ordered exactly in the same case, though it is only for the purpose of persuasion, because if for divisionments I cannot rely on exactly the similar case, my lord. My lord, Honorable, very same Honorable Single Judge, my lord. My lordship will the post of junior scientist being a class 2 post, Pitson having been appointed as postgraduate research fellow, he has been allowed to discharge the duty uninterruptedly and was continuing in NIT Bhavan Patna. Thereafter, by the office order dated 27/2/98 and Annexure 5, he has been transferred and posted as in his own pay scale against the post of technical post DLAP, Fulbani pursuant to the said order of transfer. The petitioner joined in new place of posting and has been continuing there till date. For the period he has rendered service against the post of junior scientist. No. It is the class 3 post, which is a class 2 cadre post. Necessary experience certificate is also issued to competent authorities. Thereafter, discharging his duty, the authorities also issued experience certificate. Even though the petitioner discharged his duty against class 2 post, unreasonably, he has been deprived of class 3 post. It is there in the judgment itself, my lord. Then, my lord, may kindly see the relying on the para 7, my lord. Research assistant. He was working as a research assistant. Para 7, my lord. Relying on quoting regulation 49, sorry, statute 49, page 5, para 7. Admittedly, petitioner has been appointed and posted as a research fellow against the vacant post of research assistant, and he was posted against the vacant post of junior scientist as mentioned in Annexure 4. The petition dated so and has been discharging duties uninterruptedly against the post of junior scientist, which is a class 2 post. Here, junior assistant, lecturer, but in my case, here in this case, junior postgraduate research fellow acting as against the post of junior scientist, a class 2 post. Research assistant, he was a representative research assistant. As per the provisions contained in clause 49, since the person is considered for substantive appointment as allowed to discharge the duty against the permanent post, is entitled to get the benefits according to clause 49 of the statute. Similar question came up for consideration notice now so and so, was disposed by judgment dated so and so, whereby the division of this court came to hold that 49 was fairly applicable to the case of the petitioner therein who are similarly circumstanced as the present petitioner having been appointed pursuant to the advertisement issued by the authorities. The divisions of this court further directed the petitioner's case in the said writ application should be first considered in clause 49 of the statute and referring to the same, Dr. Sarvanayan Mishra claimed similar benefit to this number so and so. Division bench of this court delivered judgment on 17th of 2008 extending similar benefit passed for the following order. That the lordship, because I was the counsel in the Sarvanayan case and other cases also. But the lordships of permitted to read it division judgment. On the consideration of arguments made by the learned counsel for both the parties, and we find that argument advanced by the learned counsel for the university cannot be accepted, since very same argument had been advanced on behalf of the university in the court of so in the consideration of the same has been rejected in said petition. That writ application also I was arguing. At the same point, at this point, I relevant to quote annexure 2 of the counter affidavit. Accordingly, petitioner belonging to AGPL economic subject was appointed a PGRF against the vacant post of junior scientist NIRP Bonapatna by the office order number such and such, annexed herewith as annexed B. He joined as such on 23/6/1993, a copy of which annexed herewith annexed C. Since petitioner has not been appointed against in the class 2 program, he has not been given the scale of pay meant for this head post, and hence the claim of the petitioner to give him consequential benefit of class 2 post from which date joining as PGRF is not possible. That is the counter by the OUT. The aforesaid government the university clearly indicates that there is a vacancy of class 2 post, and though the board of management for selection of PGRF selected the petitioner for the purpose of being appointed against the said vacancy due to the certain problem, though the petitioner was appointed as PGRF, the appointment was made against the vacant post of class 2 post cadre of the university, as has been done in this case. Accordingly, writ petition is allowed. The opposite party university directed to consider the case of the petition in terms of clause 49 of the university statute and to make substantive appointment of the petitioner against the vacant post cadre which he presently holds, along with consequential benefit. This direction may be carried out to the period of 2 months from the date of communication of this judgment. The above judgment of Dr. Sarvanayan has been assailed by the OUT before the apex court in special SLP, and on being admitted, the same was registered as civil appeal number so and so. Subsequently, said civil appeal came to be dismissed as withdrawn. Thereafter, judgment passed by this Supreme Court in this case of Sarvanayan has been confirmed by apex court. The prisoner having similarly circumstances like that of Sarvanayan Mishra, benefit would also be extended to him when conformity with the provisions contained in clause 49 of the statute. For the foregoing reasons, this court is opinion that prisoner right accrued the person to annex of 4 dated from date of the appointment postcard discharge since he has been called upon to perform junior scientist class 2 post. The objection raised by the OUT is that he is not entitled to get the benefit, cannot sustain in the flow. Accordingly, opposite party university directed to consider the case of the person in terms of clause 49 of the OUT statute, appoint him substantively against the vacant post of class 2 post with effect from on which the petitioner has been discharged his duty, extend all consequential benefits are due and admissible. Division bench judgment, this argument was made advanced before the division bench judgment. Sarvanayan Mr. case, other Mr. case, or 5 cases, my lord. And that argument has been rejected. Applying for 49, regular statute 49, the lordship's division bench, as well, which has been followed by the honorable single judge, my lord, is unusual. So division bench judgment by and my
is not applicable in his case because he was holding the scale of pay of the class 3 cadre post. The statute 49 says in the grades payment, that means that had he been in the scale of pay of a class 2 cadre post for a temporary post or a tenure holding a tenure post, then substantial appointment should have been issued. That is the statute 49. So statute 49.
Very same argument was advanced in those cases, and the cases have been rejected.
And the issue was already been decided by this honorable court. She was satisfied. Till 2003, from 2003 to 2008, she didn't prefer any appeal against that order. That means she was satisfied. The advertisement was made for post of lecturer. She applied and she got selected and she was appointed. When the post of professor was advertised, Miller, she found that she doesn't possess the required year of experience. Again, he made a representation to the authority to consider him to retrospectively from the year 1990. That is the whole of my function. So, rightly, the honorable single judge has dismissed the
No, but the first argument my learned friend is making that the statute in 49 is not applicable. That part has already been settled by this honorable court in 2-3 division. This judgment has relied upon by in this year, but the judgments also I can by mistake it left in the office, it not brought. But division bench judgments are there, so division bench judgment is very clear. The statute 49 is applicable. To that extent, honorable single judge finding that statute 49 is not applicable is wrong, because very some honorable single judge, my lord, this judgment has relied upon in another case of the earlier division bench judgment, which has been confirmed by the Supreme Court and granted the relief to the and fact is also similar, because they are
division bench you are talking about.
division bench, my lord, the division bench judgment.
What is that?
My lord, by mistake, my lord, it is there left in the office itself. Good, see. Yes, my lord, Subramanian Mr. judgment is there, my lord. I thought.
Yes, it is there.
Yes, my lord. It is there. Because
WPC 14049 of 2006.
14049, right.
49 of 2006.
2006. Because the same are
annexure ଅଛି।
let's see what it meant.
जो B रे तांको जो account of the
because I was the counsel in all these cases, so judgments are not only there are other similar judgments are also there.
ଏଇଥିରେ କଣ ହେଇଥିଲା ଏଇ ଯୋଉ ଆପଣଙ୍କର
ଜଜମେଣ୍ଟ ଦେବି, ଜଜମେଣ୍ଟ ଅଛି ମୋ ପାଖରେ ଦେବି।
ଏଇଟା ପାଇଲୁଣି ଆମେ ଡକ୍ଟର ସରପଞ୍ଚ
Lastly, they have referred to 49.
Yes, 49. No. I relied upon that 49. Correct, 2 time, my lord. The relevant facts germane to the present proceedings are that the Board of Management of OUT passed resolution dated 24/11/1990 to appoint postgraduate research fellow students against class 2 vacant posts in various research schemes. It is submitted by the learned counsel for the petitioner that petitioner possessing the necessary eligibility criteria duly sponsored by the Employment Exchange was called upon to face selection process consisting of the written test and viability test for the post of PGRF on 24/12/92. On being found competent, was duly selected through rigorous selection process, and the petitioner was appointed as a junior scientist at NARP, one partner with a vacant, which is a vacant class 2 post. It further submitted that since date of appointment, the petitioner has been discharged in duties in the best of his ability, for which he has been transferred from time to time. As continued to assess, there was a auto stagnant in the career made representation dated 19/5/2006 to and 22/7/2006 to Vice Chancellor on Annexure 7 series invokes Rule 15 of the VAT statute, observing the petitioner in the post was still lying. Duly performed his task and personally cast on him from the date of appointment, that is 13/5/1993, which is now more than period of 15 years. And in terms of clause 49 of the statute, the person entitled to be considered for substantive appointment in their permanent post. He further submits the present petitioner. Present case is covered by the judgment of this court rendered in case of similar situated position of France than the Misra and others. In the division bench of this court, presided Honorable Justice V.P. Das, Honorable Justice A.K. Samudre, the judgment dated so and so came to hold that 49 is squarely applicable to the case of the petitioner. Therein were similarly circumstances as the present petitioner, and they had been appointed pursuant to the self-same pattern. The lordships were further pleased to direct that case of the petitioner would be first considered in terms of clause 49 of the statute from the notification under annexure 8 to the petition, dated 15/2006. It appears that OUT, in compliance with the direction as noted herein above, have been pleased to appoint the petitioner wherein therein on a regular basis. In the light of the aforesaid content, contention, Mr. submits that deed properties ought to be allowed and for the similar direction may be issued along with the consequential service benefit. Please to release with the petitioner. The GS Misra Land Council, GS Land Council appearing for the OVT and the other submitted clause 14 would have no applicable to the present case since petitioner appointed again vacant permanent post of PGRF, which was the class 3 post and pay scale is similarly applicable to grade 3, as my learned friend is arguing now. On a para 5. On a consideration of the arguments made by the London Council for both the parties and we find that argument advanced by London Council for the university cannot be accepted since the very same argument had been advanced on behalf of the university before rejection number so and so and this court on consideration of the same had rejected such contention. At this point it is relevant to quote paragraph 2 of the counter affidavit filed by the university which is as follows. Accordingly, petitioner belonging to AGRL Economic was appointed as PGRF against the vacant post of junior scientist NIRP one Patna by the office order number so and so annexed here with as annexed B. He joined assets on 23/6/93, copy of which is annexed C. Since petitioner has not been appointed in class 3, class 2 cadre post, he has not been given the scale of pay meant for the said post, which the claim of the petitioner to give him consequential benefit of class 2 post from his date of joining as PGRF is not possible. The aforesaid amendments of the university clearly indicate that there is a vacancy post of class 2 post, cadre post, though the Board of Management for Selection PGRF selected petitioner for the post purpose of being appointed against said vacancy due to certain problems. Though the petitioner was appointed as PGRF, his appointment is made against the vacant post of class 2 post of the cadre post against the university as has been done in this present case. It is further appears that petitioner right accrued from the date of his appointment in 93 as PGRF since he has been called upon to perform the duty of class 2 cadre post. Therefore, the objection raised by the student council appearing for the university is rejected. Accordingly, petition is allowed. And the other Kedarnath Mishra case under lordship can also because the judgments I have not brought my lord because that Kedarnath Mishra case and other cases because I had conducted around 7 cases read petitions my lord basing on this person and all these read petitions are allowed. So this second contention, my lord, is that the earlier writ application is concerned. My humble submission would be that it will not be because first of all that honorable court had not rejected that prayer. Honorable court simply said that go for regular prayer and that not rejected that prayer. So that prayer was still kept open to be considered. The secondly, my claim is under the statute and there is no estoppel against law and under the statute. That only matter.
Land senior advocate for the appellant and Mr. Ashok Kumar. What is your
S.C.
Mr. S.C. Land Council appearing for the OUAT Bhubaneswar. These are the two parties.
Yes. There are two parties. No other party.
No other party.
No other party.
Okay. So, Board of Management.
Both respondent 1 and 2 are the OUT.
Is the chairman Board of Management also same?
Same. So OUT.
So opposite parties for them.
Opposite parties.
Opposite parties. The hearing is judgment is
and petition is left with only 3 months of service. If she succeeds, then she will get some more salary and pension accordingly. Well, permitted to can I am required to written note of submission by Monday, my lord.
Acha. Then we are doing one thing, Mr. Mitra. We are bringing it on Monday. So
you file.
Acha, like in the hearing closed now, after Grand Council, Mr. Grand Council, Senator will submit that you file. The argument is closed and you file a written note of submission on 18th of November 2022. This matter. The 18th of 19th for 19th of November 2020. This matter.
We don't know 19th ballot, so it will come in supplementary. Possibly.
Under the heading of to be non-term to file the written note of submission. Hearing is closed.
Applicant number 2, 7 years above.
Only 7 years, more than 7 years or
More than.
Well, take some time notification on the challenge. Almost a decade. It's at the concluding stage. Or if you can take some time, you can terminate. Who is appearing for the other side? The state and business department. Panel change ହେଇଛି ତାଙ୍କର? ନା। କହିଥିଲେ ତାଙ୍କୁ। Maybe at the time of call he will. Okay. Oh, yeah.
Supplemental list, item number 1.
How many applicants are there? Mr. Nayak, all total, how many appellants?
one applicant.
One appellant. Business petition of flag is regarding engagement of advocate Deboti Soren.
Last part, flag Y. Flag Y.
Flag Y.
Flag Y.
ଏଟା କାରଣ ବିଶ୍ୱଜିତ ନାୟକଙ୍କୁ ଜେସିଆର ଦେବା ନାଇଁ ଅର୍ଡର ଲାଷ୍ଟ ହେଇଛି 16/8
ଏଇ ଯୋଉ ଦିଟା ପିଟିସନ ଆସିଛି flag X ଆଉ flag Y ରେ latest କୋଉଟା? White ହେଇଛି 2024।
ହଁ
White ଟା
ଏକ୍ସଟା 22
ଠିକ ଅଛି ତାହେଲେ
ଲାଷ୍ଟ
ଅଛି କିଛି। Have you filed your V now, Mr. Nayak? All right. Here is the prisoner's petition at flag Y, wherein the pair has been made to engage Mr. Vishwajit Nayak as the counsel. Mr. Nayak has already filed Bhinama, which is accepted. The name of other counsel except Mr. Vishwajit Nayak and his associates are not be reflected in the counsel. Yes.
Miller have filed an application for bail. Miller.
That is IN number 125 of 2024.
24.
Yes.
Miller, other I stay relation 5 me. But I'm giving a copy of the declarations to my learned friend.
Right. IN number 1, so this is an application for bail. How many years he has?
12 years.
12 years. You have received that surrender, custody certificate?
No.
Land counsel for the petitioner submits that the petitioner is in judicial custody for 12 years. Land counsel for the state seeks some time to produce the custody certificate. Put of this matter will be commencing from 25th of November 2024. IN number 1 says realization of fine is allowed.
Copy of the requisitions handed over.
The land counsel for the appellant handed over the requisition copies of the witnesses examined in the trial court to the land counsel for the state. Take some time to go through the same and obtain the custody certificate. Here.
Item 2.
Mic use করুন।
Yes.
लिखी जाए तो CRLA number 112 of 2018. Business petition at flag X has been received, wherein there has been made to engage Mr. Chittaranjan Sahu as the counsel. Mr. Sahu has already filed Bhinama, it is accepted. The name of the other counsel except Mr. Chittaranjan Sahu and his associates will not be reflected in the court. Yes.
This case,
you have filed a bail application?
Yes, my lord. Earlier also filed by that.
That's 289 of 2018.
Yes, my lord.
Okay. So, offense
is my lord. 22, 34 IPC, my lord.
Okay. So how many years you are in custody?
Should be custody one Bolaram Hon'Ble is, my lord, 8 years, 16
नहीं
days.
नहीं कस्टडी सेक्रेटरी ये कंफर्म करें
There are two uplands.
Yes, my lord. One Bolaram Hon'Ble is, my lord, 8 years, 12 days. 8 years, about 8 years and 16 days. And other one is, my lord, 6.
ଏଇଟା ହଉଛି ଆପଣ ଯୋଉଟା ଦେଇଛନ୍ତି ଏଇଟା
ଆଜ୍ଞା
ଅର୍ଜୁନ ଗଣ୍ଡାର
ଆଜ୍ଞା
ଅର୍ଜୁନ
ଗୋଟେ
ଗଣ୍ଡାର
ବଳରାମ
ଲେଖିଛନ୍ତି 6 year 5 months.
my lord 2 months already gone. 6 months 6 years 7 months.
ଆଚ୍ଛା ଏ 2000
No,
ଜୁଲାଇର
ଆଜ୍ଞା
what about this ବଳରାମ?
is 8 years, my lord.
କାଇଁ
Sir, please.
your
हाँ
so whether your bail application was earlier rejected?
No, my lord.
First time.
बलराम
Yes.
7 years 10 months
So what is the prosecution case? Come to the judgment, let us see.
Yes, my lord.
You take
PM, the informant along with his brother, Jesus Sagaria Shekhar, deceased, while in their respective houses. At the time, the accused persons, namely Balaram Gonda, Arjuna Gonda, Madhava Gonda, Utpatti Sagaria, came out of their house. The deceased protested them not to use filthy languages in the village premises. But suddenly, the accused person surrounded the deceased, assaulted him by means of fist blow kicks. Thereafter, the accused person, namely Balaram Gonda, Arjuna Gonda, Madhava Gonda, controlled the deceased. Another accused, Utpatti Sagaria, suddenly assaulted the deceased by means of an axe to his forehead, causing bleeding injury, and the deceased fell down on the spot. My lord. Suddenly, there was a holla, and he went to cry. On hearing holla, the village.
what happened to that Utpatti?
Utpatti Lord gave a blow, my lord.
No.
She
What
expired.
happened? Well, she was found guilty.
Yes, my lord.
So where is his appeal?
I think she already expired. Lord.
Oh, it's perfect. So all the persons who were facing trial, 3 persons were found guilty.
My lord.
Balaram is there, Arjuna is there, and Utpatti.
Yes,
Utpatti is dead according to you.
my lord. Reporting. My lord.
जॉब पूर्ण ଅଛି
ହଁ
ଜବ୍ ପୂर्ण
ଆଉ ଗୋଟେ ଆଲିଗେସନ ରହୁଛି ଆଉ ଯୋଉ ଲୋକଟା ରହୁଛି ତା ନା ସିଏ କଣ ଟ୍ରାଏଲ ଫେସ୍ କଲାନି କି?
Sir, Madhava.
ମାଧବ ଗଣ୍ଡ
Not facing trailers.
3 ଜଣ ଧରିଲେ
ଆଜ୍ଞା
ଉତ୍ପତ୍ତି ମାରଲା ଯୋଉ ଆକ୍ସ ରେ
ଆଜ୍ଞା
forehead କୁ. So who are the eyewitnesses to the occurrence?
we do 1, 5, 6 and 9, my lord.
1, 6,
5 and 9.
1, 5, 6 and 9.
Yes.
Doctor?
Please, my lord. PW8, my lord.
PW8. 8 है.
Yes. One single blow, lord.
Doctor के evidence तो आगे आसिलो तापर जीवा.
My lord.
Single blow.
Yes.
Forehead.
intensity was very high. The longitude over right forehead just above right mid eyebrow cutting right frontal bone muscles, exposing ruptured vessels, nerve and brain.
Carry internal injury would have 6 injury. So the role attributed is that they caught hold of
Due to their control, the main accused could able to get a chop blow in the forehead.
let us come to the evidence of one eyewitness, PW1. First, they dealt fist and kick blows. Come to PW1.
Yes, my lord.
Where he has stated that all the accused persons at this juncture, all the accused persons caught hold of them, uncle, and dealt fist blows, and at that time, so on. So how do you say that they caught hold of?
Because of
that?
their, because he could not be played away. Otherwise,
No, that is not the thing. You see, ଗଣ୍ଡଗୋଳ ହେଲା ମାନେ ସେମାନେ ତାକୁ ଧରିଲେ ବାଡଉଥିଲେ, ଇଏ ସେତିକି ବେଳେ ଟାଙ୍ଗିଆ ଧରିଥିଲା ତା ଛୋଟକୁ ଦେଲା। ତେଣୁ ସେମାନଙ୍କୁ ଆପଣ କେମିତି କହିବେ ଯେ because they caught hold of it that facilitated all the
because the only 3% that caught hold a person.
No, you are not, just read out that evidence once again. At this juncture, all the accused persons caught hold of the my deceased uncle and dealt fist blows and kicks. At that time, ତାମାନେ ଯେତେବେଳେ ଏମାନେ kicks blow out ଇଏ ଧରୁଥିଲେ ସେତିକି ବେଳେ accused Utpati was holding a tangia and dealt tangia blow on the head of the deceased uncle and caused the bleeding injury. ତେଣୁ ସେମାନେ ତାକୁ ଧରି ମରାମରି କରୁଥିଲା ବେଳେ ଇଏ ଛୋଟଟା ଦେଲା।
So it means all were coming in a group.
If you are advancing the argument as if they caught hold of that facilitated the other accused, main accused who is already dead.
Yes.
But the evidence is otherwise. ସେମାନେ ତାକୁ ଧରାଧରି ବିଧା ଗୋଇଠା ମାରୁଥିଲେ ସେତିକି ବେଳେ ଇଏ ଗୋଟେ ଟାଙ୍ଗିଆ ଧରିଥିଲା ଛୋଟେ ଦେଇଦେଲା। ମାନେ ଦିଟା ତା ଭିତରେ ଡିଫରେନ୍ସ ଅଛି, ତାକୁ ଷ୍ଟାଣ୍ଡ ପୋଜିସନରେ ରଖି assaulted by means of that tangia.
If they would have come in a group.
Group ଠିକ ଅଛି, group ଅଛି, let us say ଇଏ କଲେ ସେମାନଙ୍କ ହାତରେ କିଛି ଅସ୍ତ୍ର ଶସ୍ତ୍ର ନଥିଲା, ସେମାନେ ତାକୁ ବାଡିଆ ପିଟା କରୁଥିଲେ, ଏତିକି ବେଳେ ଏ ଲୋକଟି ଯୋଉ ଟାଙ୍ଗିଆଟି ଧରିଥିଲା ଛୋଟେ ଦେଲା। ତେଣୁ ତା ସାଙ୍ଗରେ ଏଇଟା ସେୟାର୍ଡ କମନ ଇଣ୍ଟେନସନ ହବ ନା that would be the individual act. ଏମାନେ ହୁଏତ ସେ ବିଧା ଗୋଇଠା ପାଇଁ ରେସ୍ପନ୍ସିବଲ ହେବେ, but how do you say that they shared common intention with the man who assaulted on the head of the deceased, for which they would also be liable for 3-0. Of course, these are things which is to be adjudicated at the time. ଆଉ କିଏ ଅଛି ଆଉ ସାକ୍ଷୀ?
Yes.
Five.
Five, my lord.
ସମସ୍ତେ ସେଇଆ କହୁଛନ୍ତି। You see, PW5 ମଧ୍ୟ ସେଇଆ came outside at that time, ସେମାନେ slaps କରୁଥିଲେ, ଲାତ ବିଧା ମାରୁଥିଲେ, accused Sagaria dealt tangia blow on the right side. ବୁଝିପାରିଲେ ନା, ଏଇଟା ଆପଣ ଯୋଉ କହୁଛନ୍ତି ନା ତାକୁ ଧରିକିନି ରଖିଲେ, ତାକୁ ମୁଭମେଣ୍ଟ କରିବାକୁ ଦେଲେନି, that facilitated, that is not the evidence. The evidence is that ସେମାନେ ତାକୁ ବିଧା ଗୋଇଠା ମାରୁଥିଲେ, ଇଏ ତା ହାତରେ ଯୋଉଟା ଧରିଥିଲା ଦେଲା ଛୋଟେ। ତ ଏମାନେ are the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submitted that the petitioner is in it of prothomta likhibe, petitioner is in judicial custody 7 years. And 7 years came on to it as এটা কেবেকার এটা reason I don't know, not মাসে 7 years 11 months করতে
PW6 is something other into one. PW6 at that time Utpati holding the axe. When my husband protested about the abusing words by the poor accused person at that time, Madhav Baram Arjun surrounded by my husband and controlled my husband and dealt blow at that time accused Utpati giving a tangia.
That is contrary to the other evidence. So 23/9/24, 7 years 11 months is taken on record. The land council further submits that the main assault has been attributed against accused Utpati Sagaria, who stated to have dealt tangia bracket hatchet blow on the right side forehead of the deceased. This is not the one. This is the lie. Acha, Shekhar Sagaria alias Jisudan Sagaria. The rule that has been attributed against the petitioner is that they caught hold of the deceased and dealt fist blows and kicks. He argues that there is no material that due to overtact committed by the petitioner in catching hold of the deceased, that facilitated the appellant, the co-accused, Utpati, to dealt Tangia blow on the head of the deceased, and therefore it is difficult to attribute common intention against the petitioner. It further submits that there is no chance of early hearing of the appeal in the near future, and paper book has no, paper book is ready, and therefore the bail application may be favorably considered. Surrender certificate is taken on that one. Learned counsel for the state opposed the prayer for bail and placed the evidence of the eyewitnesses, PWA के 5, 6 and 9. So also the doctor's evidence, bracket link on PW 8, who has noticed one external wound, that is a chop wound on the right forehead, and opined the cause of death to hemorrhagic shock, which was caused by a sharp and heavy weapon like that. Considering the submission made by the land counsel for the respective parties, the nature of evidence adduced by the prosecution, nature of overtact against the petitioner, period of detention of the petitioner in judicial custody, and absence of any chance of early hearing, we are inclined to release the petitioner on bail subject to usual condition. आरटा जो अच्छी सीआरएल नंबर अर्जुन गोंडा तर पीरियड ऑफ डिटेंशन टा अलगा ଆଉ ବାକି ସବୁ ସମାନ ରହିବ ହେଲା ନିଅ ହଁ ହଁ ଆଉ ଏ ଯୋଉ ଷ୍ଟେରିଲାଇଜେସନ ଅଫ ଫାଇନ୍ ଟା ଦେଇଛନ୍ତି ସେଟାକୁ ଆଲାଉ କରିଦେବେ
Item 3.
Convicted under section 302 in custody seems 17/8/2015.
Last occasion, Lordship direct to take criminal antecedent. The letter was issued on it, have not received for 11. Praise some of that. And conduct of the accused both. 411 order.
Wait, who ordered 411?
411.
Land counsel submitted that petitioner produced a receipt to verify the availability of the interim of
Previously, plus it was there.
Previously. Deposition copy ଲେଖା ହେଇଛି ତ ଆମକୁ ଦେଇଛନ୍ତି ଆଉ ତ କିଛି ଅର୍ଡର ନାହିଁ item number 3 ତ କହୁଛନ୍ତି SCRL 51 of 2018 conduct କଣ ସିଏ କଣ ଯାଇଥିଲା କି interim bail conduct interim bail ସିନା ଯାଇଥିଲେ ସେ during period of interim bail ତାର conduct କଣ ଆପଣ ଆଣିଥାନ୍ତେ ତ ମୂଳରୁ ଯାଇନି କି ଅର୍ଡର ନାହିଁ ୟାକୁ କଣ ଗୋଟେ ଲେଖି ଦେଇଛନ୍ତି ଆପଣ ଅନୁମାନ So have you received the deposition copy?
Deposition copy BP Tripathi received.
କେବେଠୁ ରହିଲାଣି
17/8/2015. No, you had last time claimed only that you had not been supplied with the copy of the interim application. But the interim application earlier I have sought Millard and showed my receipt. Your Lordship directed Millard. I have again Millard. I have sought the 2 copies of the IA and deposition.
तो ट्रायल बेले आपण बेल रे नथिले
नहीं
para 2 particular judgment
my lord. The prosecution case in short is that Mangal Munda.
just prosecution case
that one Mangal Munda, PW5.
father of the deceased, my lord, lodged a written report at PS to the effect that on 17/8/2015 at about 7 a.m., the accused, who is in the son-in-law, husband of the Sukramani, my lord, came to his house and informed him that on previous night at about 10 p.m. he made a quarrel with his deceased wife and assaulted her by wooden plank. As a result, his wife died in the early morning at about 4 a.m. Getting such information, the informant along with his wife went to the house of the accused and found Sukramani, the deceased, lying dead, and blood was oozing from the left nostril, and there was mark of assault on his left arm and right wrist. On receipt of sincere information, police registered PS case number and took up investigation.
So obviously, it's a case based on circumstantial evidence.
My little confessional statement before the opposite.
Confessional nahi.
My circumstantial evidence.
Circumstantial evidence. ए गोटे हला तो एक्स्ट्रा जुडिशियल कन्फेशन
आउट हला जे से
दी जन जाक एकाठी रहउथिले डेड बॉडी मिलला घरु
आगे
अच्छा आपण एक्सप्लेनेशन कोन
एक्सप्लेनेशन 330 मिनट कंप्लीट डिनायल में
डिनायल
सी
डेड बॉडी आपण घरु मिलला अन्य माने कहउछंती
हां
आउ डॉक्टर कोन कहउछंती
डॉक्टर पीडब्ल्यू 10
10 weapon of assault is
wooden plank में
10 plank hematoma skull spinal canal so on so multiple small abrasions on the body. Hematoma present below this class organ body. My ଆପଣ ଆକ୍ୟୁଜ ଷ୍ଟେଟମେଣ୍ଟ କଣ ହେଲା ମିଛ କଥା
ଆକ୍ୟୁଜ ଷ୍ଟେଟମେଣ୍ଟ ମିଲେ କମ୍ପ୍ଲିଟ ନା ମିଛ କଥା
କେତେ ବର୍ଷ ବାହାଘର ହେଇଥିଲା
background that is silent millet that is not there in the record millet but at the time of ତାକୁ 29 ବର୍ଷ ହେଇଥିଲା ଏଇ ଲୋକକୁ
ପିଲାପିଲି
କେହି ନାହିଁ
who is the IO
IO millet PW 11
the location of the dead body in the house of the deceased ମାନେ inquest ବି ସେଇଠି ହେଇଛି ଆପଣଙ୍କର 9 years ହଉଛି criminal antecedent କଣ ଅଛି
that is not in record
ମଗେଇନାହାନ୍ତି
ହଁ ମଗା ହେଇଥିଲା 4th November ରେ ଯାଇଛି ଗୋଟେ ରିପୋର୍ଟ କ୍ରିମିନାଲ ଆଣ୍ଟିସିଡେଣ୍ଟ ସୋସିଆଲ ଇନଭେଷ୍ଟିଗେସନ ରିପୋର୍ଟ that report has
ମଗା ହେଇଛି ଆସିନି
4 November
ନେଇ ଆସୁନ୍ ସେଟା
ଆगे
the Sudan Council for the petitioner submitted that the petitioner is in judicial custody since 18/8/2015 and as such has remained in custody for more than 9 years. The Land Council for the state submitted that as per the order dated 4/11/2024, he has received the copy of the interim application from the Land Council and may be given some time to obtain instruction regarding the criminal antecedent, if any, against the petitioner. Upon custody certificate ଦେଇଥିଲି
ନା
and also custody certificate, है ना? court of this matter on 25th November 20.
Item 4.
Lordship.
Yeah.
Lordship, I'm seeking to withdraw this matter.
All right.
Item 5.
Oblige me, Lord.
Lordship, while considering the interim application for condonation of delay, Lordship had called for a report from the District Legal Service Authority.
Yes.
In the meantime, my lord, there is a prisoner's petition praying therein to engage.
No, that is there. She is there and she has also filed Vihinama. You are Mr. Behra.
Yes, my lord.
So your name has to be deleted.
Yes, my
The
Yes,
no,
yes.
that is there. The prisoner's petition at Flagi is there for engagement of C.Kosturi and counsel for his as his advocate. Was already filed Vihinama. Vihinama is accepted. The name of Mr. Prabhav Behra shall not be reflected in the cause list henceforth. So you have filed the application for condonation of delay. IA has been filed for condonation of delay. Who has filed? And what is the delay?
That's filed by the condonation of delay.
Is there any delay? Oh, 2069. So you just filed letter life convictions. Yes. Life imprisonment.
Yes, my lord. Life imprisonment.
ये आपण गोटे ऑब्जेक्शन फाइल करूँ जोड़ा 2069 दिन
My lord, his wife was also inflicted, but during trial she has died.
No, it's all right, but just let him file because of this. We have to give one opportunity, otherwise we know that
2069.
Just 2069 days means it is almost 6 years of age. So 11 IA number 1. Yes, they have reported that they have engaged you. Prisoner's petition is there and your Vihinama is there. So now you are the counsel, but we are considering your that interim application which has been filed for condonation of delay, and the delay has been reported by the stamp reporter as 2094, so almost 6 years. So that is why we are giving an opportunity to the state council to file the objection. Then it will be regularized. Okay. So IA number 1 is an application for condonation of delay. The land council for the state seeks some time file objection the interim application. What is सप्ताह पर file Court of this matter will be commencing from 25th November 2020. Yes. Obliged. This date reference will not take all the item number 12.
Item 12.
So, Mr. Nayak, please call that Mr. Das, Sanjay Das, is the Vigilance Council. His name is there, he is not appearing.
No, he was there on the last occasion because
what is this matter?
Matter relates to Millers. The notification under Section 5 of the Special Courts Act. Your Lordship knows 5.2 says it cannot be challenged in a court of court. Of course, Your Lordship also knows the power of judicial review. The nature why the notification has been passed, that is beyond judicial scrutiny. But here it's a case where I am a temporary employee having no permanent job, but wrongfully, deliberately due to reasons other than law, a reference has been made. Your Lordship may see, after prolonged hearing, my employer was made a party. Thereafter, the conclusion, my lords, order dated 13th September 2017. And for 7 years, it's continuing. My lord, may kindly have a look. 13th September 2017. When my employer was made a party, he came and filed an affidavit that this fellow would have no OSRP rules or anything. This fellow was never appointed on, my appointment order is also not there. He is a temporary employee. He cannot be said to be a highly placed public official. That is the question. And under those circumstances, this Honorable Court passed orders asking the state government how you made such a notification when this fellow doesn't come within the ambit of, by no way can be said to a person holding high public office.
You are challenging the notification.
Section 5 on notification declaring me as a highly placed public servant and referring my case to the special judge, special court under the Special Courts Act. Pradeep Kumar Raut.
Whereas it is alleged that this one so address is one so with holding high public office.
Yes.
In the state of Orissa, accounts officer and so committed an offense under section so and so, and the matter was investigated by so and so, and whereas scrutiny of relevant matters available on record, state government is of the opinion that there is prima facie case for commission of offense who accumulated property disproportionate to his known source of income by the on. It's very necessary that the government that the said offenders should be tried by the special court established on. It is therefore in exercise of this one, hereby declared that the said offense shall be tried on the Special Court Act 2006
My lord, in item 12, my lord, I may be excused, I am with the VC, my lord. In this matter, my lord, there was a direction from my lords by order dated 18th September 2023. There was a specific direction by this honorable court, my lord, that the state of Orissa ought to have filed an affidavit. That is, there is a clear-cut order, my lord. What order they have filed the affidavit or not? That is
the order I.
My lord, order.
He is for the employer. He is for the employer. He filed the affidavit, indicating my status.
It is filed already.
Yes, yes. Not by the Millards.
By petitioner.
My lord, I am for ORHTC.
Millards, it's like this. When I challenged this, saying that the Vigilance Department did not produce any document, they said we have filed in court and all those things. The case continued. After a continuous hearing, court thought it proper. They asked me to make my employer as an opposite party. Then he's appeared for my employer. They filed an affidavit indicating that he is not a regular employee. He doesn't any post. He cannot be said to be a person holding highly public office.
Where is that affidavit?
That affidavit is affidavit filed by opposite party number. Pursuant to that 13.7 order was passed. Counter affidavit filed by opposite party number 2, dated Millards, 12/9/17.
12/9/17.
17. It's matters continuing since 15. And the last order was 17, and thereafter it is adjourned for different reasons. May I place that, Millards?
My lord, with the permission, my lord, one development has been happened.
In hearing this for the first time, just let us give some time to let us go through it. Then, what is that order, Mr.
17/9/2017. It's sorry, 13/9, sorry. peruse the counter affidavit filed by the opposite party number 2, Managing Director, Orissa Rural Housing Development Corporation, Bhubaneswar, dated 19/9/2017. In paragraph 13 of the said counter affidavit, the following has been stated: that the petitioner was placed under suspension on 17/3/2007 and continuing as such. The post of accounts officer in ORSDC is neither a sanctioned, created post nor approved by the government of Orissa till today. Copy of such counter affidavit has also been served under the additional government advocate for the state. In view of such aberrations, on behalf of the ORSDC Bhubaneswar, the Secretary, Home Department, Government of Orissa, Bhubaneswar, is directed to file an affidavit or an officer authorized by him indicating under what circumstances sanction under Section 5(1) of Special Courts Act 2006 dated 13/8/14 Annexure 2 was granted. Such affidavits shall be filed on or before 10th October 17. It continued, they filed an affidavit ultimately in November 23, which doesn't serve the purpose. They have adopted the same affidavit of the Vigilance Department, but there is no answer. After 6 years, they filed it in November 23.
Affidavit filed by opposite party number 1. Somendra Patra.
November 23 minutes.
After affidavit filed by opposite party number 2. Prem Kumar Jha, Managing Director.
Aye. जोड़ा opposite party number 1, Somendra Patra.
Somendra Patra.
ସେଇଟା ଯେ 17 order ପରେ ଏଇଟା ଫାଇଲ କଲା
ସେ କଣ କହିଲେ?
କିଛି ନାହିଁ, that I have gone through the content, so and so. See that the petitioner prayed for quashing. No. There is no answer to the Honorable Court's order. They have cited some decision. Para 5 minutes. That in reply to the assertions made at paragraph 8 of the CRLMP number so and so, this deponent humbly begs to submit that whether he holds a high public office in the jurisdiction of GA and PG department and the additional superintendent of police vigilance at Cuttack has already filed an affidavit before the Honorable Court which covers the aberration made in para 8 and it also adopted by Home Department. Copy of the filed by the additional superintendent of police cell Cuttack so and so is annexed here to and marked A/1. After the vigilance department's affidavit, this Honorable Court was not satisfied. My employer was engaged. The data came to picture. Then a final order was passed. Now they don't answer the order. They have not answered. And they have some citations.
What your employer said? That particular line, that there is no...
No, Lordship, it's a... that affidavit your Lordship was saying, Jha. I'm placing it in...
No, just place that relevant paragraph. What was your...
yes, Lordship.
What was your job there?
Para 5 minutes. That the averments made in para 3 is partly correct to the extent working of the petitioner as assistant accounts officer in ORDC since 95. Initially, the petitioner was receiving some so and so per month as consolidated remuneration for his work. Copy of the payment voucher for 3,500 marked as so and so. It is false to say that the petitioner was receiving consolidated pay of 5,000 per month in the year 95. So far as the allegation of possession of assets disproportionate to no source of income is the subject matter of inquiry by the Vigilance Department. Para 8 minutes. This is what your Lordships have quoted. That the aberrations made in para 8 of the petition are clarified hereunder. After verification from the personal file of the petitioner available in the office of the ORSDC, it is found that the then management permitted the petitioner to work in the office with consolidated pay. However, no appointment letter is available in the office. Only payment vouchers are available regarding payment of consolidated pay. The service, next minutes B, the service of the petitioner has not been regularized by the state government till date, even though the same has been approved by the board in its 15th board meeting held on 26/3/1999. The service conditions of the employees of ORDC is governed by the Board of Management. Till today, there is no specific service rule for its employees to place them in different cadre group grade. The employees are governed and suitably arranged among themselves on the basis of their engagement and seniority as well as the decision of the board. Therefore, it is difficult to compare the petitioner service along with group A service of the state government for determining the equivalence. The petitioner is holding the post of accounts officer in the ORDC Limited, which is not a highly placed public office. The petitioner is an employee of the ORDC Limited having no decision-making authority. Only the directors board has the power to take decisions, including policy decisions. Then paragraph 13. The petitioner was placed under suspense so and so. The post of accounts officer in ORDC is neither a sanctioned or created post nor approved by the government of Orissa till today. So virtually, much less to say I have the power, mere accounts officer, no decision-making authority. I don't have a
definition of high public.
It's not there, Your Lordship remembers. The buyers were challenged. Then in the roots, they have adopted that vigilance.
With permission, some development has been occurred in this matter. That on 24th September 2018, the Vigilance Court has convicted this person. On the basis of that conviction, the ORHDC has also dismissed the order in favor against the Pradeep Kumar Raut Miller. On
that is no relevancy in this case.
No.
No.
Memo.
ORDC has several other cases.
No. Just a minute, Mr. Sahu.
My lord.
You Bhubaneswar Vigilance PS case number 34 of 5 रे
trial
conviction is in.
एग्री 24/9/2018 रे conviction हला जन conviction हला परे the ORHDC
case charge discharge पे ही होची. I am the counsel there.
ORHDC in connection with vigilance PS case number कितने सेट है?
My lord, vigilance.
What is that vigilance PS case?
Case रही कोचंती.
Vigilance PS case number, my lord, 56/2.
Oh, this is 34.
It is 34, Mr.
My lord, it's like this. In ORDC, some raids were conducted. Coincidentally, I was an employee there. I was there. My house was raided. In that connection, nothing was found from my house. What they did, I applied for a loan from the bank. I said my house will be cost 30 lakhs, and that is the 30 lakhs, no gold or anything. They just...
No, we are not entering into that. Just
No. I am clarifying what he is saying. In the original case, there is a trial, there is a conviction. The raid was conducted in connection with that case. They found nothing, but they made a DA case. So we are not on merits. So now this case is pending.
Who is saying that the cost of the building was 30 lakhs? The petitioner or the vigilance?
They found nothing. Their engineer said 8 lakhs. They said the building is 30 lakhs because to avail a loan, I stated before the bank that my house will be 30 lakhs. Your Lordship, no, that cannot be the consideration. The consideration has to be basing on the PWD department's not on merits. So he is mixing both of it.
Section 5. If the state government is of the opinion that there is prima facie evidence of the commission of offence alleged to have been committed by a person held high public and political office in the state of Orissa, the state governments have made a declaration to that effect in every case in which the appropriate declaration are made. So where is that definition?
Yes, my lords. Yes. My lords, so far as since your lordship is not concluding, I have books, but overall I am saying, my lords. My lords, the Special Court Act was challenged before this honorable court.
That
yes.
Whether it is defined anywhere?
No, in the rules they have added.
Where is that rule?
Subsequently, Special Court.
Personal holding by office E, 2E. Next page.
Lords, definition, Orissa Special Court Rules 2007. Section 2E. 2E. Person holding high political office, we are not concerned. Public office
includes
under section so and so, including so and so, and belonging a service. Yes. Central and state government. All
So-
officers of equivalent.
No, what they have done, Millers, for reasons, so we are not concerned with that. What they have done by suppressing these facts, or let's say without verifying these facts, the mischief played is that Group A service salary, which I was getting 7,500, but I am on a consolidated salary. I am not a approved or government.
Let us understand first
Yes.
this rule. We are not going to your case. What is
All right.
person holding high public office includes a public servant falling within the meaning of 2C of the Prevention of Corruption Act 1988 or Section 21 of the Indian Penal, and including all India services working under so and so. Belonging to a service.
State government. Right.
These are necessary must be a public servant, number must be a service in the central or state government or equivalent. Who will service a service?
And in addition to that, if Lordship goes by Lordship's decisions, must be a person who has a decision-making ability, is highly placed person. Group A service, there the mischief has been played.
What post you are there?
Accounts officer.
Account
And
officer.
my counter filed by my employer that there is no such OSRP rules were never made applicable. I was on the consolidated pay. Let's go back to that employer's condition. So then I will point out, Millers, what they have done. That they have clarified in para C.
Did you, Mr. Sanjay, plus filed that affidavit? এটা তো ইয়ে ফাইল করতে হলে হোম ডিপার্টমেন্ট টু ফাইল করতে
Because the last order was, this Honorable Court last order was directing the state government to file it and answer that query, how you have made it. Instead, what they have said,
have you got that file with you?
No, I don't have.
Then we are not satisfied with this file, this affidavit. Affidavit was filed. The answer we
That did
require,
not answer.
you have to answer that. What is this type of affidavit? Somendra Patra. What is that order? Mr. That is 18923.
13/9/2017, that was repeated again.
18920. In view of such government made on behalf
Yes.
of also, the Secretary Home Department Bhubaneswar is directed to file an affidavit. What circumstances sanction on the
answer to nahi.
take down. The heard Mr. Devasi Sarangi, Land Council appearing for the Land Council for the state, and Mr. Tunasa, Land Council for the opposite party, number 2. None appears for the Vigilance Department. As for order dated 18/9/2023, this court, taking into account the order dated 13/9/2017, directed the State Council to comply such order and to file an affidavit. The affidavit has been filed by Somendra Patra, Deputy Secretary to Government, Home Department, wherein the points raised by the petitioner in the CRLMP application has not been answered. So it is stated that the notification, imposed notification is completely legal, justified, and sustainable in the eye of stop. The imposed notification, which has been by the government home special section department, is that the petitioner, while holding high public office in the state of Odisha, that is accounts officer, Odisha Rural Housing Development Corporation Limited, Bhubaneswar, East Khurda, committed an offence under clause E of subsection 1, section 13 of the Prevention of Corruption Act 1988, and the matter was investigated in Bhubaneswar Vigilance PS case number 34 dated 22/11/2005, and on scrutiny of the relevant materials available on record, the state government was of the opinion that there is prima facie case of commission of offence by the petitioner who has accumulated properties disproportionate to his known source of income by resorting to corrupt means, and accordingly the government was of the view that the petitioner should be tried by the special court established under subsection 1 of section 3 of the Special Court Act 2006, and in exercise of the powers conferred by subsection 1 of section 5 of the Special Court Act 2006, the state government declared that the said offence shall be dealt with under the Special Court Act 2006. Section 5 of the 5.1, the 5 of the Visa Special Court Act 2006 is quoted in the hearing. On the clear reading of the section makes clear that if person high public or political office in the state of Odisha has committed an offence and there is prima facie evidence for the commission of offence, then the state government shall make declaration to that effect that in every case, such state government shall make a declaration to that effect in every case. And it further said that such declaration shall not be called in question in any court. The offence has been defined under section 2D of 2006 Act, that is of criminal misconduct within the meaning of clause E of section of subsection 1 of section 13 of the Prevention of Corruption Act 1988. However, there is no definition in 2006 Act relating to high public or political office. However, in Orissa Special Court Rules 2007, the person holding high public office has been defined, which is as follows. Quote for them to 2E. The learned counsel for the petitioner, referring to the counter affidavit filed by the opposite party number 2, Prem Kumar Jha, who is the managing director of ORHDC Limited, submitted that the petitioner was working in that office with a consolidated pay and no appointment letter is available in the office, and only payment vouchers are available regarding payment of consolidated pay. And the service of the petitioner has not been regularized by the state government, and the petitioner was holding the post of accounts officer, which is not a high public office. In view of the specific stand taken by the employer, it was nonetheless the requirement on the part of this court to seek for an affidavit from the state government as to how in the impugned notification they came to the conclusion that the petitioner was holding a uh, uh, high public office for which they were of the view that the offense shall be dealt under the Special Court Act 2006. Most unfortunately, the affidavit filed by opposite party number 1 is totally silent on that aspect. It is expected of the authorities to carefully go through the governments taken in the CRLMP and the grounds of challenge and the purpose for which the court requires an affidavit to file, and they should have met the query of the court. Therefore, the affidavit filed by the state is not acceptable. Let the state government, who has been directed to file that?
GA department.
कितने number order है? Let the secretary
GNPG.
Home Department को चाहिए.
Sorry,
view of such government manager, the Secretary Home Department, Government of Odisha is directed to file. Let the Secretary Home Department, Government of Odisha, Bhubaneswar, file a better affidavit with better particulars, and within 4 weeks, matter will be listed thereafter. A free copy of the order be handed over to the Learned Council for the state for compliance. Copy of the affidavit be served on the
It's already there. Affidavit is already there. It's still 2-3 years. Right?
Which affidavit?
And issue to that employer.
We don't accept it.
We are not accepting it. We are asking
past order
by a better affidavit and meeting all your points which you are. So that copy of the affidavit is to be served on the Land Council for the petitioner, to also the Land Council for the opposite party.
They have not answered the query made by the court in that.
Yes.
My premier source में treated as parted. We have for a decade. I have a very checkered.
So we can after 4 weeks
fix a date at least.
So weeks means today. So it will come in the week commencing from 16th. If it does not come, make a mention in week commencing from 16th. 4 weeks will be passed. So
because there is no interim order. Of course, there was no progress. Recently, discharge petition is being heard.
Obligement.
Yes, next. Who is there? Is there anybody?
I am in the 14. I am in the 14.
No, ଆମେ କଣ ମନା କରୁ କି ପେପର ବୁକ୍ ଟା ଥୁଆ ହେଇକିନା ଅଛି ଆପଣ ଗ୍ରହଣ କରିବେନି କଣ ହାଇକୋର୍ଟ ରେଜିଷ୍ଟ୍ରି ଯାଇ ଆପଣ ଘରେ ଦେଇକିନା ଆସିବେ ନା what do you expect whose name is that there? Anuraga Mahapatra. Who is he? So today he is not present. You are making a mention on his behalf. So ask your friend to collect the paper book, sign here in the order sheet and get prepared. It's a 2010 appeal. Mr. Counsel, when you receive the paper book, it contains everything. What are you doing? And if he is not interested, there are other counsel we can engage him. We list this matter next week. It will be listed next week. Whether he will argue this matter next week or not. He has to remain present, collect the paper book tomorrow itself, and get ready within 2 days, and the matter is to be argued next week. Otherwise, somebody else is to be engaged. That's all. Okay. 2010 appeal and paper book is ready. The man has been sentenced to life imprisonment. You have been entrusted with a duty, and 14 years have passed, and you are saying that I have not received paper book, as if somebody has prevented you in receiving the paper book, deprived of you your right of getting the paper. Yes. With this matter, a mention is made of so and so. Let Mr. Mahapatra receive the paper book tomorrow from the registry. Matter will be listed on 18th of November 2024. It's made clear that no further adjournment shall be granted. And if Mr. Mahapatra does not come ready with for hearing, some other counsel from the panel shall be engaged. Yes. Next. 14.
There is
Same order for me. Yes. Number 3,